Lordship.
Settled.
Your Lordship, parties have settled.
Monday.
Lord.
For withdrawal.
My lord, may I be permitted?
Non-commercial.
My lord, may I be permitted for listing of a testamentary matter? It is ready.
Ready?
Yes.
My lord, may I be permitted to mention a matter, my lord? Your lordship was pleased to fix it on 17th and 19th, my lord. My lord, for examination of the witness action, my lord. If your lordship may kindly give any other date.
Who is for the other side?
My lord,
I'm
served, my lord.
I'm opposing this prayer, my lord. Kindly see the order. Knowing fully well the condition of the petitioner, my lord, petitioner is a third stage cancer patient.
Well, I am informing the for advance, my lord.
Delaying this matter.
I am led by Mr. Rohit Banerjee, my lord. Kindly keeps it any other day, my lord.
50,000. I will adjourn 50,000 per day.
My lord.
2 dates, 1 lakh rupees.
I'll finish it in 1 day, my lord.
Okay, no problem. 17, 19, I will defer it subject to payment of cost of proof 50,000 per day, because 20 November the case is fixed. At the last moment, you are telling to the court for adjournment, and the witness is old age and suffering from some ailment. The court will grant. There is no problem.
My lord,
Payment of 50.
Kindly keeps it on 19th, my lord.
Okay, I am recording the submission.
Kindly keeps it on 19th only. I'll finish it on 19th, my lord.
Once the 2 dates have been fixed.
My lord, 19th you have fixed it. The 19th is the date fixed, my lord.
I am not hearing.
May I mention, my lord, one PLA matter is ready for the hearing. One PLA matter.
May I have your lordship leave to mention a matter?
Make sure. Make sure come with the 50,000 if your witness will not come.
May I have your lordship leave to mention a matter? Probate matter, lordship. I'm praying for inclusion for issuance of citation.
Yes, call them.
Commercial list or judgment item number 1.
And I appear for the bill.
Dismissed.
May it please, my lord, I appear for the plaintiff. The matter is appearing at my instance. Lord, pursuant to my lord's last direction, my lord, I have obtained a service report from the deputy sheriff dated 26th of November. Lord, it provides that the summons was duly served upon the defendant on 29th of December 2023. No written statement has been filed as on date. Lord, I am praying, Lord, for marking of the suit as ex parte and Lord for further directions.
Date of summons could not be served upon due to incomplete process.
Yes,
Summons
Lord.
could be sent to the civil court, Navi Mumbai, as per the report of process server. Then,
Lord, service through postal department says item delivered, the last column, addressee on 29th of December 2023. Till date, my lord, we haven't they haven't filed any written statement yet. And they haven't also entered appearance. Your lordship may either call for a report from the deputy sheriff or from the registrar, and then my lord may kindly marks the suit as ex parte.
Lordship, I am from the respected lordship. We have recently assigned in this matter. Kindly give us a 2-week time to file a wakalatnama.
No.
it's a commercial suit.
Yes, lordship.
File a wakalatnama. But
Lordship,
when your client has received the writ of summons, madam.
Lordship, I am not my senior Devtanay Banerjee. So, as per the instruction, I am just.
Sole defendant.
Sole defendant, Lord.
So and so suffering for the plaintiff. The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. The plaintiff has handed over the service report dated 26/11/2024, wherein it reveals that the writ of summons could not be served upon the defendant due to incomplete process as per the report of the process server dated 31st January 2024. In the same report, it is also reflected that the writ of summons was also sent through the speed post, and the same was duly delivered to the addressee on 29/12/2023. Based on this report, counsel for the plaintiff prays for fixing the matter in the list of undefended suit. Submit that in spite of the writ of summons, neither defendant entered appearance nor has filed written statement. Full stop. At the time of hearing, Leonard, what is the good name?
Your name.
Bishodipa Mandal.
So appeared and submit that she has instruction to appear in the matter and prays for leave to file wakalatnama on behalf of the defendant. Full stop. Full stop. As the matter is listed as to be mentioned and Leonard advocate appearing for the defendant, accordingly, let the matter appear. Let the matter appear on 23rd of December 2024 under the heading for orders. Full stop. The defendant is liberty to file the wakalatnama in the meantime, subject to scrutiny by the
Lord,
defendant.
in the meantime, they should obtain the status when they have received the writ of summons.
Let you
on that
obtain.
date. No, my lord. They should give the date.
They will
I'm
not
giving
come.
the date.
But you are not obtained the report, whether written statement and
Very well.
appearance. So how they can appear?
They said that they haven't even entered appearance.
Let
Very
them,
well,
that's
very well.
why.
Very well.
That's why you
Extremely-
not pass any other on that.
Very well.
Grateful.
Extremely grateful.
आपका report be kept with the record. Yes, next.
I'm waiting for the results after the exam.
Huh?
I'm waiting for the results after the exam.
Examiner is very strict.
Lawyer always wins. Either way.
GEOCOM is 2 is allowed. Department director to return the plaintiff is at liberty to file the same before the appropriate.
Lord, with regard to the court fees, Lord, may the court fees be returned.
On merit.
My lord, it's my application under Section 8. My lord, I have taken instruction that since the award has already been passed, that Lordship may dispose this application off as having become infructuous in view of the award.
But I was only submitting them. I can't really tell them anything about their decision, but because of the award is passed, they don't press. Then may kindly record in even if that impresses your lordship that the point taken by me are not gone into.
No, that I
The
have
allegations are not gone into.
Yes, I am not gone into merit of the case as per the submission.
Yes.
The GA it is disposed of.
Great.
Yes.
Great.
Where is the award?
So, my lord, the engine has failed.
The award I have annexed for it with my affidavit.
Affidavit in reply.
No, but affidavit in opposition to the supplementary affidavit. Kindly sees the affidavit affirmed on 5th December 2024.
ये देखो कहाँ है?
It was handed up on the last day. GA4.
GA4. GA4.
Affidavit in op-
The award is at page 18.
Last picture then.
Yes, and the date of the award, Lordship will find at page 30. That's the last page one.
Affidavit.
But is named as affidavit in opposition.
To the supplement. 5th December.
Yes, 5th December. Page 18 is where the award starts from, and page 30 is the date.
So-and-so offering for the plaintiff. So-and-so offering for the defendant. Defendant had filed an application being IA 4 of 2023 under Section 8 of the Arbitration and Conciliation Act 1996, praying for referring the parties to the arbitration. Though the matter was heard at length, but in the meantime, heard at length, but in the meantime, learned counsel for the defendant submits that the arbitrator has already passed an award on 25th of September 2024 2024, and as such, the defendant is not intending to proceed with the application filed under Section 8 of the Arbitration Act. Full stop. As counsel for the defendant submit that as the arbitrator has already passed an award, and thus the application filed by the defendant being GA4 of 2023 under Section 8 of the Arbitration Act become infractuous. Thus, the same as dismissed as infractuous, and it is made clear that this court has not gone into the merit of the said application.
Disposed of as infractuous.
Merit of the said application vis-a-vis the lord, the defense taken by the plaintiff, lord.
Without going into the merit of the matter,
So at the threshold.
Yes.
Great.
We appear for the farmers.
Well,
The defendant number one.
yes,
application
well,
was
it's
by
the different number one, and well, instead of dismissed, lordship,
Okay, as filed, no, the counsel for the defendant one submits that whatever the defendant stated, defendant one, and infractuous accordingly so and so disposed of.
He doesn't praise that application. That
yes, yes.
Become infectious, J4 is disposed of.
Great.
This matter, Millard, they have
Settled.
applied and filed the undertaking before Millard, Justice Kapoor Millard, and by consent there is a decree in terms of prayer A of the plaintiff Millard, and I have not pressed for that. And Judge Sahib, did you reach? Last order the in view of that, nothing remains of the contempt application, Millard. Lordship, he has passed an order, Millard will draw up the decree. Very fair on Millard.
Appearing for the plaintiff public petitioner, appearing for the defendant of the contemner, full stop. The plaintiff had initiated the present contempt application for violation of the order passed by this court dated 30th September 2024. Full stop. It is submitted that subsequently the defendant has complied with the order passed by this court dated 30th September 2024, and accordingly, the suit filed by the plaintiff being IP Com 33 of 2024 is decreed in terms of prayer A of the plaintiff. Thus, this court find that nothing survive in the application.
Decreed in terms of the undertaking read with prayer. That is what the judge. In light of the undertaking and read with prayer. That is what he has.
Decreed in terms of prayer A, in terms of the undertaking, in terms of prayer A, as per the undertaking filed by the alleged contemner.
Great.
Alleged contempt. In view of the above, this court find that nothing remains in the contempt application. Accordingly, CC Com 17 of 2024 is disposed of.
Grateful.
Rule: if any issued, is recalled.
Suit is disposed of within 1 or 2.
Good. So I think first disposal in the IP.
First is great.
Yes, next. Item 10.
Item 10. My learned friend has served an affidavit, Millard, day before yesterday, Millard. So, Millard, I need Millard time, Millard, to Millard file a reply.
GA1.
Yes, GA1, because initially, Millard, it was Millard SRMB sold Millard unauthorizedly, but it was SRMB. So, Lordship's view was until affidavits are filed, this cannot be decided. So, Millard, they are out of time, Millard. They have any event filed it, Millard. I wish to file a Millard reply. Lordship gives me time and keeps it any date after the vacation. It's a part heard before you, Lordship.
My Lord, in this matter, I'm on behalf of the respondent, and my Lord, I'm led by Mr. Amarjit Kumar.
My Lords, I'm appearing, my Lords. Yes. My Lords, there is one submission, my Lords, I just want to make. Now, my Lords, what was being served, because what for fall from my Lords is everything has been served in the present case, my Lords. Now, when the matter was initially when this matter was being filed, a copy was being served upon us. Subsequently, we appeared on the first day.
Yes.
We appeared on the first day. there was some amendment which was been asked by my lords to the plaintiff to do it, and then subsequently a GA was being served upon us. So what today has been served upon us is the GA application, where we appeared, we argued the matter that has been disposed of. Now,
No, that is disposed of. That's pending.
Regard to they
Be
wanted
heard
the
out finally.
interim order was refused and given an opportunity to you to file affidavit so that the matter can be the GA1 can be disposed of on merit after the exchange of affidavit. Now you file the affidavit, let they file the reply, that
Yes,
will be decided.
that will be decided, my lord.
Please, my lord. So one, as far as the suit is concerned, my lord, I have not been served with the copy.
I have served the plaint also.
That the writ of summons will come to.
There is some process going in the department. IP division has been formed.
So that is, I am just concerned with the suit part, my lord. So yes, definitely.
Now, this court is not having the suit jurisdiction.
Plain.
But how
they have taken steps?
So how this GA will be here?
Parted before your lordship. Parted. This is parted.
So
39 1 and 2 has been GA has been dismissed, my lord.
No.
It is
David direction.
Interim
You have
was
not read
disposed
the
of.
order.
Interim was not allowed.
Yes.
Actually, that should be ad interim, but you had appeared. That's why you are not taken as ad interim.
So my lords, that is what 39 1 and 2.
As per our original side rule, if they appeared, we can note your submission, but the opportunity is to be given for affidavits. Otherwise, tomorrow you will say, or your client will say, or the change advocate will say, we will not given an opportunity to file affidavit. That's why that is the provision.
There was some confusion with my local counsel. I'm so sorry.
Suffering from the plaintiff, suffering from the defendant. Plaintiff has filed an application. Defendant has filed affidavit in opposition in connection with GA Form 1 of 2024 after serving the same to the learned counsel for the plaintiff. Let the same be kept with the record. Counsel for the plaintiff press for time to file affidavit in reply. Let affidavit in reply be filed within
Millard,
a week after
vacation.
A week after winter vacation. Full stop. Let the matter appear on 17th January.
Grateful.
2025.
Millard, in item number 5, I forgot. Special officer should be discharged. I have paid his remuneration.
A special officer appointed by this court is discharged.
Grateful.
Paid remuneration paid?
I have paid. I have done it.
Thank you. Next.
My lord was pleased to extend the interim order on the last occasion, but my lord had inquired rightly about the affidavit of service. The affidavit of service down original. My lord, may I file the original affidavit of service by which the plaint petition and my lord the initial
File the supplementary?
Yes, my lord. Supplementary also, my lord. I am filing, my lord, today. My lord, kindly takes the supplementary. My lord, supplementary a copy down. The copy of the kindly takes the supplementary affidavit. I have said that the banks that I have served on pursuant to your lordship's order, but kindly, my lord, come to paragraph 4 and 5. They kindly come to paragraph 5. With regard to the bank accounts maintained by the respondent number 1 with Punjab National Bank and Standard Chartered Bank, I have failed to communicate the said order of injunction as the said banks have refused to receive the copies of the plaint and the application. With regard to the bank accounts maintained by the respondent number 3, even though I have succeeded in communicating the said order of injunction, no response has been received from Axis Bank or Standard Chartered Bank. However, communication has been received from ICICI Bank detailing that the said bank does not maintain any account of the respondent number 3. And that letter has also been annexed. But in these facts and circumstances, I have made further efforts to locate any other was-through accounts that the respondents might have within their Indian counterparts so that the protections offered by the Honorable Court could be given effect to. Upon such inquiry, I have been able to ascertain the following was-through accounts belonging to the respondents. Respondent number 3, AB Bank, Mumbai branch. And respondent number 2, Standard Chartered Bank, account number such and such, and Standard Chartered Bank, account number such and such. I submit that if necessary orders are not passed for extending the protection offered by this honorable court over the additional accounts, the respondent might remove and siphon off the balance amount to defraud its creditors, and essential that this honorable court exercises discretionary power of attachment to secure any amount that is existing in the aforesaid banks. Now, my lord, kindly see your lordship's order, which I have annexed as Annexure A, 10th May 2024. Your lordship was, my lord, satisfied with our case, and finally, my lord, in page 9, the penultimate paragraph in internal page 3, your lordship has, my lord, allowed accepted the case, and my lord, in page 10, penultimate paragraph, your lordship has restrained the respondent number 1 and 3 from withdrawing and or transferring any amount from the bank accounts as mentioned in paragraph 53 of the present application without leaving a balance amount of USD 1,10,000 equivalent to INR 91,57,000 till 9 July 2024. This has been extended. Now, my lord, I am saying that two of the banks that are mentioned in paragraph 53 have refused to accept, and my lord, the third has said that he does not have the Vostro account. My lord, in that view of the matter, I was humbly beseeching your lordship to extend the order of 10th May, my lord, to the banks mentioned now in the supplementary affidavit, so that I can catch hold of, my lord, the Vostro accounts. Kindly come to paragraph 53.
Yes.
ICICI Bank, under paragraph 53, has said he does not have any bank account, any Vostro account. That letter is also annexed, my lord. And my lord, 1 and 3, that is, my lord, Punjab National Bank and Standard Chartered Bank has refused to accept. And my lord, Axis Bank has, my lord, Axis and Standard Chartered Bank has not, my lord, said anything.
What about the Punjab National Bank?
Punjab National Bank has refused to accept, my lord. I have stated, my lord.
Where is that? Refusal?
Paragraph 5, my lord. With regard to the bank accounts maintained by the respondent number 1 with Punjab National Bank and Standard Chartered Bank, I have failed to communicate the said order of injunction as the said banks have refused to receive the copy of the plaint and the application. So there are two Standard Chartered banks, my lord. I have also filed the affidavit of service. Lord, I am beseeching your lordship, my lord, kindly extend the order of 10th May to, my lord, the bank accounts that my client has been diligent enough to trace out at paragraph 7 of the supplementary affidavit. It's very difficult to find these Bangladeshi banks, my lord, and that too, my lord, with the current situation, once the money is gone, my lord, we'll never be able to recover.
Yes.
And my lord also kindly issues a direction for affidavit.
It was served.
Yes, my lord. The affidavit of service has been filed. কপি আছে এই যে অরিজিনালটা ফাইল করেছে সাপ্লিমেন্টারি এখন মেন এটা মেন অ্যাফিডেভিট অফ সার্ভিস বল বস না মেন রেসপন্ডেন্ট সার্ভিসটা দেখো
So and so appearing for the plaintiff. None appears on behalf of the defendants. Plaintiff has filed affidavit of service. Let the same be kept with the record. In spite of service of notice, none appears on behalf of the defendant. The plaintiff has filed a supplementary affidavit stating that the respondent number 1 with the Punjab National Bank and Standard Chartered Bank refused to accept the copy of the plaint and the application. As regard the respondent number 3, who is the respondent number 3? Union Bank of
Union Bank.
The plaintiff has served the order of injunction, but no response has been received from the Axis Bank. Axis Bank is not a party here, no?
No, my lord, Axis Bank is named as one of the Vostro account holders of respondent.
Has not received from Axis Bank or Standard Chartered Bank. Full stop. Counsel for the plaintiff further submit that a communication has been received from ICICI Bank, wherein it reveals that the defendants, the respondent number 3 is not maintaining any account in the said bank. Counsel for the plaintiff submit that the plaintiff has made further inquiry to locate other Vostro VOSTRO capital accounts of the respondents, and on inquiry, the plaintiff found that the respondent number 3 is maintaining the account at A capital B capital bank, Mumbai branch, having account number AC 5001 dash 000072 dash 155, and the respondent number 2 is maintaining the account in the Standard Chartered Chartered Bank, being account number 323, page number 5 and 6 of the supplementary. Yeah? So
It is better that he copies it from there.
Counsel for the plaintiff submit that as the plaintiff has received the information that the defendant number 3 and defendant number 2 and defendant number 3 are maintaining certain accounts in the banks mentioned above, and prayed for a direction upon the defendants to maintain the amount which is reflected in the interim order, initial interim order passed by this court dated 10th May 2024. That is the amount USD 1,110,000, equivalent to Indian rupees of 91,57,500. Consider the submission made by the counsel for the plaintiff as none appears on behalf of the defendant in spite of service of notice. Accordingly, the interim order passed by this court dated 10th of May 2024 is modified only to the extent that the respondent number 1, but there is no interim order against the 2. Kindly see the page number 4 of the interim order, 1 and 3.
Yes, my lord. But all 3 are, my lord, under the letter of credit. All 3 are, my lord. That time we did not have any details of respondent number 2.
In the respondents number 1, 2, and 3, or their man, servant, agent, men assigns and men, assigns are restrained from withdrawing or transferring any amount from the bank accounts.
Paragraph 53 and, my lord, paragraph 7 of the supplementary.
Yeah, this one, paragraph 53, 70, and the bank account
Paragraph 7 of the supplementary.
Paragraph 5, 7, A, B, and C. C. Full stop. The counsel for the plaintiff interim order till today.
Oh, my lord, it is extended, my lord. Your lordship had just extended.
When it was extended? 3rd January 2020.
Yes, my lord. My lord, let there be directions for affidavits also before we can ask for, my lord, a final order.
though the defendants have not entered appearance in spite of the receipt of the notice of the application, comma, the defendants are directed to file their affidavit in opposition, if any, within a period of 2 weeks, comma, reply, if any, there to be filed within a week thereafter. But 3rd January will go.
So, my lord, kindly extend it a little further.
And it is not good. Now it should be extended. Within 2 weeks, then let the matter appear on 3rd January. Only reply not then. Affidavit in opposition filed within 2 weeks. No, reply it. Reply. Let the matter appear on 3rd January.
Then I have to write the reply during Christmas.
No, that's why you're not given the reply time.
Very well, let the affidavit come.
Otherwise, it will go
Yes,
above.
yes, my lord. And my lord, it's not required to be kept in the order, but I shall serve the supplementary affidavit also on the respondent.
The plaintiff is directed to serve the copy of this order along with the supplementary
My lord.
affidavit to the defendants.
This is my application, my lord.
It's his application for attachment before judgment. Before my learned friend opens his case, my lord, I have a counter claim. I'm filing it today.
That may be today. My application is to be heard, my lord.
Lordship. I'll come back if your lordship permits tomorrow with the
Written
counter.
statement filed.
29th of November, they have served the plaint, my lord. We are on the 16th of December. I have a counter claim.
When it was served to you?
29th of November.
November. So within time.
What is more relevant, though, my lord? One thing lordship will consider. Kindly have the last order of 29th November, my lord.
Counsel for the defense, they have not received the same.
Your lordship will kindly have the second page of the order, my lord, 3rd paragraph. Counsel for the plaintiff submits that by an order dated 3rd July 2024, the appellate court had directed the defendants to furnish the annual report of the accounts of the financial year 2023-2024 and the statement of withdrawal tallying with the annual report, but the defendants have only furnished the report issued by the chartered accountant wherein table has been provided. Why this is relevant, I tell your lordship. In this matter, my lord, I had already obtained an ad interim order where your lordship had directed, my lord, that all bank accounts associated with these PAN numbers be restrained from withdrawal without keeping apart the amount claimed in the suit. My lord, the division bench modified that order, saying that, yes, you will be entitled to withdraw in commensurate with your expenses for the last years, your average expenses. For that, you will provide the annual audited annual report. So, my lord, the respondents have been contending that they still had time to have their accounts audited, so they have only given a chartered accountant statement. On the basis of that, they have been withdrawing. Now, my lord, to my humble understanding, accounts are to be filed within September of the year. Time has come and gone. Still, my lord, the audited accounts have not been furnished to me. What is being done is they are taking advantage of the division bench's order and, my lord, continuing to withdraw, thereby, my lord, essentially rendering the order I have in hand nugatory. Kindly have,
Will kindly have a look at the order. I think
division bench order is, my lord, 3rd July.
Not the substance of the order of the Honorable Division Bench.
Kindly see the second paragraph.
12th August 2024, my lord.
My lord, the division bench order. No, my lord, 3rd July is the interim order. 12th August, the appeal was finally disposed of.
Or shall kindly see that order once. 12th August.
When appellate company shall furnish to the respondent the annual report.
Yes.
Or accounts for the financial year 2020. Appellant shall be permitted to withdraw the bank account every month a sum represent the average withdrawal from the account for the last one. A statement of such withdrawal tallying with the annual report issuance should be furnished by them to the respondent. Yes.
So, my lord, these accounts have not yet been furnished to me.
Or shall kindly see the order of 12th August. What is the clarification which has been given by the Honorable Division Bench?
By consent of the parties, let the affidavit action interim order be following direction.
The 3rd paragraph, my lord, on the first page.
We only clarified in case of annual report of the appellant has not been prepared, the statement certified by the director or the company secretary may be furnished.
Yes, that is until the annual reports are prepared and filed. My lord, the time has come and gone.
Annual report of the appellant has not been prepared. Whether annual report is
It has been prepared. It's been uploaded. It's a public document.
That was August 2024.
We'll give it immediately. We'll give it.
And lordship will finally hear the application of the pleadings are complete, ready for hearing. My lord, I'm prepared to go on.
If it's ready, I am no problem.
Yes, my lord.
I'm fine, my lord. If your lordship is willing to take it up, my lord. Only one thing, I have a counterclaim which is far in excess of his claim in the suit.
That is
Lord, which
subject
is in
matter of
excess
trial.
of 87 lakhs. He
That
has
is
a
a-
claim on account of alleged security deposit. I say, my lord, the security deposit firstly has to be adjusted
Let me
against the
open my
rental due.
case. It is my
And
application.
over
I
and
have
above,
the first
there
right
was
of
a
audience.
50% remission given because there was COVID. It does not
My
mean
learned friend
that the
cannot
balance
hijack
money
my
has not been.
application. My learned friend cannot hijack my application. I have the right of first audience. Kindly allow me to open my case.
What is the one for interim prayer?
Yes, my lord, for interim prayer. Ad interim, my lord, lordship had
Ad interim
granted.
ex parte order
The
was
division
granted,
bench has
from which we
modified.
preferred the
Yes, division bench's order, my lord, has seen. Now, my lord, the application is to be finally disposed of.
Even heard also when the order can be passed. How much time you will take?
I will take, my lord, 15, 20 minutes.
You will take further.
Your lordship
Come,
wants us to come back, we'll come back, my
after
lord.
vacation.
Very well.
So what about the written statement? I am accepting this.
Yes, please
So we'll
accept it, my
affirm it
lord.
and file it in.
Within 30 days?
Yes,
No.
yes. 29th November they have
Within
served.
30 days?
Yes, yes.
He's saying writ of summons has been served.
So appearing for the plaintiff. So appearing for the defendant. Full stop. Counsel for the plaintiff submit that. In the interim order passed by this court was initially modified by the Honorable Bench by an order dated 3rd July 2024, directing the defendant to furnish to the plaintiff its annual report or accounts for the financial year 2023-2024. Subsequently, by an order dated 12th August 2024, the Honorable Division Bench has modified the said order by clarifying that in case the annual report of the appellant has not been prepared, a statement certified by the director or company secretary may be furnished. Full stop. Learned counsel for the plaintiff submit that though in the month of September of each year, the annual report is to be prepared, and by that time, full stop, prepared, and the defendant might have been prepared the annual report but has not been served. Full stop. Counsel for the defendant submit that he will serve the annual report by
within 7 days. It's now
within a
available
week-
online. He can
within a
also
week-
access it.
within a week from date. Full stop. Counsel for the defendant filed a written statement along with the counterclaim after serving the. Have you served?
No, my lord. We'll affirm it and file it today.
Not served.
No, no. We'll serve it and we'll affirm it and file it and serve it on them.
No, not for counsel for the defendant prays for leave to file written statement along with the counterclaim in course of the day.
In course of the day.
In course of the day. Full stop. In view of the submission made by the counsel for the defendant is directed to file the written statement and the counterclaim in course of the day after serving the copy to the learned counsel for the plaintiff. Full stop. The department is directed to accept the counterclaim subject to accept the written statement along with counterclaim subject to scrutiny. Full stop. As the defendant has filed the counterclaim, accordingly, the plaintiff is at liberty to file the additional written statement within 30 days from the date of receipt of the counterclaim. Pleadings completed.
In the application, it's
It
completed.
is submitted that pleading in connection with GA 1. Form 1 of 2024 is completed. Let the matter appear on 10th of January 2024.
Please,
Great.
10th of January 2024 under the heading adjourn motion.
I'm grateful.
2025.
Next.
I appear for the plaintiffs. My application for judgment on admission. But here, my lord, the defendant has not been appearing, and my lord, lordship has granted my lord, directions for affidavits. They have not appeared and they have not filed the affidavit. My lord, it is ready for hearing.
What about the writ of summons?
The writ of summons was served on 16th August 2024.
They entered appearance.
No, my lord, they have not entered. My lord, this is the mode of service. So, far as the writ of summons is concerned, and this is the report by the deputy sheriff that they have not entered appearance.
When it is served?
The writ of
30th
summons.
August.
my lord, one is by registered post on 16th August and through the jurisdictional court on 20th August. My lord, if your lordship considers the 16th August, the 120 days that are expiring on 16th of December. No, my lord, 14th of December.
No, 120 days.
Yes, my lord, August, September, October, November, and December.
September full, October full,
Yes.
November full, December 14.
Yes, yes. But 16th August, 120 days comes to 14th of August, which is 14th of December, which is tomorrow. Lordship will kindly, I don't want to make a prayer for undefended suit now. Kindly keeps it in the next week, any day, Tuesday or Friday. 20th, if
So that will be better. I will take
yes,
both.
yes, my lord.
If they will not come undependent suit, you adduce
My
the
lord,
evidence.
my lord,
and
that is
will
what
be
my prayer is.
so appearing for the plaintiff, so appearing for none appears on behalf of the defendant. Full stop. Plaintiff has handed over the service report wherein it reveals that the writ of summons was served upon the defendant on 13th of August 2024.
No, my lord. 16th, it was served on 16th. 13th August was
16th of August 2024. Full stop. Counsel for the plaintiff also handed over the report issued by the Deputy Registrar within bracket legal dated 4th of December 2024, wherein it reveals that none defendant has not entered appearance either in person or through the advocate till 4th of December 2024. Full stop. Consider the report. This court finds that time to file written statement is still not completed, and as such, the case is adjourned. Let the matter appear on 23rd of December 2024 or after vacation.
Before that,
19th of December, 20 December.
20th December, my lord. Grateful. But the affidavit of service of His Lordship's last order may be kept.
Affidavit of service filed by the plaintiff be kept with the record. The report, copy of the reports may also be kept. Give the copy of this report.
My lord, I shall.
Affidavit of service and the reports. Affidavit of service and the reports be kept with the record.
Grateful.
Lordship will keep it on Friday, next Friday, Lordship. We have sent the entire document. The matter has been compromised, Lordship. I have got the original also of the year. It has to be annexed to the formal format and it will be filed next Friday, Lordship.
As per the prayer made by the counsel for the plaintiff.
Plaintiff.
Plaintiff. Let the matter appear on 20th. 20th. Under the same heading.
Keep your place.
Next.
Yes, Lordship. In this, through VC, I am connected. We have moved an application for Section 8 Arbitration and Conciliation Act in the civil suit, commercial. There's an arbitration clause. Am I audible, Lordship?
Yes.
There's an arbitration clause whereby it is very much clear at page number 3, para 4 of GA 3 2024. Any dispute, controversy, or claim arising out of or relating to this contract or breach, termination, invalidity thereof shall be settled by arbitration in accordance with the Indian Arbitration Conciliation Act 1996 as amended from time to time and rules made thereunder. The place of arbitration shall be Jaipur in Rajasthan. So, yes. Lordship, they have filed a suit, and in this suit, they have said that there is no arbitration as such, but we have moved the application for Section 8. So, Lordship, the basic controversy is the plaintiff has challenged those things in the civil suits and not challenged the other tenders. There are
file affidavit.
No, my lord, I don't think affidavit is required in this. This is not an application under Section 8, Order 7, Rule 11. They have claimed. Let him place it on
yes.
Yes.
Because rejection of plaint, the averments made in the plaint are to be true and correct.
Lordship, there is a valid arbitration agreement.
But what the application you filed?
Lordship, it is Order 7, Rule 11 for the rejection on plaint and sent to the arbitrator. Because Section 8 is very much clear.
See, rejection of plaint is something, sir, on
the basis of Section 8, that's what I am seeing, Lordship. At
And
page number.
kindly come to your prayer.
Yes, Lord. Yes, Lord. Yes, Lordship. At page number 10, para 14, hence the aforesaid facts and the circumstances, it is most humbly prayed that your Lordships would graciously be pleased to reject the plaint of the instant suit in lemni with the exemplary cost and pass such other orders or order as your Lordships may deem fit and proper for the ends of the justice.
Yes.
Lordship, basically, this is the arbitration clause at page number 135. Can you peruse?
Yes.
This is the general conditions of contract. At the top, it is written general conditions of a contract. Lordship, basically, the issue which revolves is there are two other separate tenders. One tender they have done separately, Skipper, the plaintiff has done. Another was the Skipper has done a joint venture with the Power Tech and Skipper altogether. In that tender, there is a condition, they have not fulfilled the tender conditions and they have not completed the work. There is a JV contract, joint venture contract, plaintiff had done along with the Power Tech, a company. Okay. In that, they have not completed the complete contract conditions. They have not completed the work. It is the work of crores of rupees. Now, in that condition, it is written, if the contractor goes in between and the contract is terminated, I will show in the paper book. If a contract is terminated in between, then the defendant number 2 will give the work to risk and cost to any other person. Okay. And after giving, that recovery of risk and cost amount shall be done from the JV partners, that is Power Tech as well as Skipper, that is a plaintiff. Now, in that, due to which we have stopped and encashed the bank guarantees. Now, a separate tender for this civil suit is there. In this, an arbitration clause is there, subject to a Jaipur jurisdiction. I will show you in a paper book, Lordship. In this arbitration clause, Section 8, very much clearly in the various judgments, Avatil, Rashid, Raza, my learned friend is over there. He will supply the copy of all the judgments. Vidya Drolia, Aya Swami, NN Global. There are various, and Lordship has also passed various judgments. I was also seeing in the morning also, the various judgments where there is a specifically arbitration clause. The matter shall be referred to arbitration. There is no such type of a fraud. The plaintiff has made Indian Bank as a first party. And seeing that the Indian Bank is situated in Calcutta, that the jurisdiction lies in Calcutta, but there is a specifically arbitration clause. In a specific tender, they can move to the arbitration and get the matter adjudicated. There is no such type of a fraud. And on the previous day, on 19th November, I have deposited whole amount as per the directions of the court. The matter can be very well settled at the arbitration also. The amount is also there, being deposited in the Indian Bank, and a FD deposit has been created. Arbitration proceedings can take its course, and finally, as per the contractual conditions, where it is very much clear there is an arbitration clause, then, and jurisdiction is also Jaipur, that it cannot lie in West Bengal and Calcutta also. So all these are my amendments in my application. This is my application. I can go through all the pages and the relevant documents where I can show. Lordship, can I show you on page number 478?
Yes.
Lordship, clause number 44.2.6. These are the two tenders, JV tenders, joint venture tender with Power Tech Engineers and Skipper, the plaintiff. In this, the condition is third para. If such excess is greater than the sums due to contractor under GCC, subclause 44.2.5, the contractor shall pay the balance to the Nigam. And if such excess less than the sums due to the contractor under 44.2.5, the Nigam shall pay the balance to the contractor. If the amount is, we did the work at risk and cost at a low price, then we will pay him. For facilitating such payment, the Nigam shall encash the bank guarantees of the contractor available with the Nigam and retain such payments due to the contractor under the contract in question and any other contract that the Nigam have with the contractor. So by this, by this, we forfeited the amount that any other contract. So Skipper was doing the independent, plaintiff was doing the independent contract also. So in that, the bank guarantee was retained. And they have, we are a power utility, state utility, and we have given a tender to them. This is a public money. And they haven't complied to all the tender obligations in the separate tender. And they have left the work in between. And that's a crores and huge public losses there. Rural electrification is also not being able to be completed by due to this. They have to, when it's a public money, they have to do something. They have to comply with the tender. When it is a joint venture, they have to do it. And there is a, and if I go, Lordship, to the page number 177. Now I come to the contract of the plaintiff, where he has challenged. There is the arbitration clause under special conditions of contract. This is our document of defendant number 2, where they have signed it. Lordship, in point number 18, GCC 45. Here it is written, rules of procedure of arbitration proceedings at the bottom. The contract with the foreign contractor, this is for the foreign contractors. On a very next page, Lordship, on a very next page, B point 178, the contract with contractors being nationals of the employer country. Any dispute, controversy, or claim arising out of relating to this contract where they are challenged it, or breach, termination, invalidity thereof, shall be settled by arbitration in accordance with the Indian Arbitration and Conciliation Act 1996, as amended from time to time, and the rules made thereunder. The place of arbitration will be Jaipur. So, Lordship, these are the things. Now I come to my application. Para number 2. Lordship, in para number 2, the tender number BN 9019001708. This is a tender which they have before the Lordship. This is the case of the tender. This is an independent tender. Now coming to the below to it, this is a tender of 2021. There is a which were floated by we defendant, also floated another tender BN 901500 2003 and 2006 in 2021 and 30th April 2020. These two are the tender where plaintiff being the JV partner with the Messer Power Tech, the lead partner. Lordship, on a very, we have annexed all the work orders of the separate. This is annexure 1. This is specifically. Now, there is an arbitration clause I have shown you in the Lordship in the paper book at para number 4, which is being reproduced over here. This is pertaining to a specifically this civil suit.
Yes.
Page number 178. It is at the paper book.
Yes.
So from this GCC clause, it is very much clear that there is an arbitration proceedings.
Yes.
And subject to a JEPO jurisdiction, and they have filed a frivolous and wrong case, and they have misled the court, and they have not even approached to the arbitrator, getting appointment of an arbitrator, and they should have filed a Section 9 application. They haven't done that also. And they are coming before the Lordship without filing pre-institution mediation application. We should have settled over there also in Calcutta. They should have done it, but they haven't. And they have not even completed the work. The main motive is of a state for the welfare of a public is that the work should be completed. At the end user is the public of this India.
Yes. Then
Lordship, and now coming to their civil suit, they have referred in para number 41, their civil suit, how this they are taking the matter in a manner of saying this is a fraud committed by us. We have committed a fraud and encashed their bank guarantees. And they are saying in a case of fraud, the arbitration proceedings are not there. But this is not a specific type of a fraud where testing can be done. The documents are not replaced. These are the documents retained with them also. They have signed it. Their stamp is always there. There is a valid arbitration agreement. I have shown to the Lordship. There is a stamp of a company.
where is the print? Which page? Next, the print here.
Plaint Lordship at page number 17, para 41.
Page number 70.
Plaint is not not annexed. He is referring to the plaint separately.
Plaint is
Separately, not annexed.
But the print is not here.
Okay, Lordship.
It is IS GACOM CSCOM नहीं आया.
750 of Sir, Lordship, in this, it is, I just speak out. Consequently, the condition precedent to the arbitration not being satisfied, the arbitration agreement also become inoperable and invalid. In any event, the plaintiff having composite cause of action, both against defendant number 1, that is Indian Bank, and 2, that is RVPN, and being required to seek relief not only against defendant number 2, but against defendant number 1. Lordship, they are Indian Bank is an executioner party. There is a bank guarantee. That's an unconditional bank guarantee. And cannot invoke an arbitration. They are saying this. Due to Indian Bank, this is the condition. In the absence of an arbitration agreement with the defendant number 1. There is no...
Which paragraph you are referring?
Para 41. 41.
Yes.
At the below it is written, in any event, in the half, in any event, the plaintiff having a composite cause of action, both against defendant number 1 and 2 being required to seek relief not only against defendant number 2, but against defendant number 1, cannot invoke arbitration. In absence of arbitration agreement, definitely there won't be any arbitration agreement with the Indian Bank. Plaintiff won't have. This is a bank guarantee. How come they are saying this? The cause of action of a plaintiff being a fraudulent invocation of a bank guarantee issued by defendant number 1.
Yes.
By defendant number 2.
Yes.
In any event cannot be subject matter of reference to any arbitration by reason of serious issues of fraud stated herein above.
Yes.
They are saying this is a serious issue of a fraud and there cannot be arbitration. There is no valid agreement with the Indian Bank. That's why a civil suit.
Yes.
Lordship, my learned friend Animesh Paul would be there. He will supply the copy of the various judgments.
Yes.
There is a compilation. Lordship must be very much aware of these all judgments. These are not they are reportable judgments. At the index, I would like to show.
Yes.
Avital Post, Rashid Raza, Amit Lal Chand, Ayaswamy, Nilesh Sejwani, NN Global, Deccan Paper, Vidya Drolia, Lion Engineering, Suresh Dhanuka, Madhusudan, Fultron, and there are various other judgments, Lordship. And Lordship, at J, a flag at J I have marked. Lordship's judgment only at J. It's a Lordship's judgment where Lordship has said there is a valid argument, arbitration agreement between a party, and at a para number 26, objections will nevertheless be raised both in section 8 and 11. These objections can be genuine, such as where there is no arbitration clause, where the matter is itself non-arbitrable, but often the objections could be only in wriggle out of the statutory commitment of the parties to define process of redressal mechanism. Considering the above facts, the circumstances, the court finds the plaintiff is not established a prima facie case.
Yes.
Lordship, I can satisfy to the Lordship. There is a prima facie. There is a valid arbitration agreement signed by the parties, by the plaintiff and defendant number 2. Bank is an executioner party, and we have already deposited and complied to the order of the Honorable Court. And it's a state utility, and the work they have left in between. The skipper has left in between.
Yes.
Just Lordship, wait a second. I just 313. Lordship, 314, my paper book. I show you the work order. There is a letter of award given to a Power Tech and a JV partner skipper. Lordship, these are the judgment. I can refer it out one by one. But at page number 314 of my paper book, I have also annexed the contract done by the plaintiff and a Power Tech engineer. And Power Tech engineer has also filed a writ petition in High Court in Rajasthan. And there is no stay. That orders I can peruse to the Lordship also at page number 314. There's a Power Tech.
Yes.
There's a Power Tech engineers from and to. This is a Power Tech engineers and JV partners skipper. This is a letter of award. These are the 2 tenders. They haven't completed the work.
So what you want to show from here?
Lordship, I just want to show you from here that this is a JV partner. Plaintiff is a JV partner in that. Just that only I just want to show you to the Lordship.
Okay.
And they have not completed the work of, that is, transmission lines, development, everything. This was a tender given to them. And this is a 132 kV GSS.
Yes.
And now they are coming before the Lordship with a very fraudulent and a misleading act by saying that we have done a fraud. And there is no arbitration clause by a plaintiff and a Indian bank, defendant number 1. That's why a civil suit is there.
Yes.
And they haven't showed any type of fraud which we have committed. If we would have committed a fraud, we wouldn't have deposited the amount. We have deposited the amount. We have shown our bona fide to the Lordship. And within a time frame, as per the order, on the very same date, within a time frame by the directions of the Honorable Court, Lordship. I remember that very day when I was present before the Lordship, and the whole system worked as per the directions, but the Lordship, here, all the misleading acts being done by the plaintiff should be stopped and my application may be allowed. And there is a valid arbitration agreement between plaintiff and defendant number 2. And my application is Order 7, Rule 11 for the rejection of plaint on a basis of Section 8 application. And if I go by the wording to the Section 8, Lordship.
The arbitration. Yes.
A judicial authority before which an action is brought in a matter which is the subject of an arbitration agreement shall, if a party to the arbitration agreement or any person claiming through or under him so applies not later than the date of submitting of his first statement on the substance of a dispute, then notwithstanding any judgment, decree, or order of the Supreme Court or any court, refer to the parties to the arbitration unless it finds that prima facie no valid arbitration agreement exists. There is a prima facie arbitration agreement is there.
Yes.
Annexure 2, I have shown that Annexure B. Lordship, there is a valid arbitration agreement. The party shall be referred to arbitrator. Arbitrators, the issue can be decided at the arbitration also.
Okay. That's all?
That's all, Lordship.
Yes, Mr. Chaudhary.
But there are three parts to my learned friend's argument. One is an argument under Section 8, one is an argument under merit, and one is perhaps an attempted argument under forum selection clause. Now, my lord, on merits, I don't think I am required to go into, but just for my lord's satisfaction, my lord will take the plaint and see what are the particulars of fraud. I don't want to use harsh words as misleading and all. If all these are in black and white, and if after all this my learned friend says something else, the question is who is misleading whom? And he has not yet filed, he doesn't have the courage to file an opposition to this. Because we are concerned with this contract. What my learned friend showed to your lordship, and power tech and all that is being referred to, is a dispute pertaining to another contract. I am not addressing on merits, I have much to say. We will cross the bridge when we come to the river. That is not the case here. Now, my lord, bank guarantee invocation was challenged on us, and number two is it has to be in terms of the guarantee. The guarantee has been given only in respect of this contract, not any other contract, because my lord, the guarantee terms are very clear. Them are under this contract.
Correct.
The entire submission of my learned friend, he does not say that in this contract work is not done, in this contract there is any amount payable. In his entire submission so long, 20 minutes he submitted, he doesn't say that. Now kindly see the particulars of fraud. Yes. Well, lord, before lordship, I place the particulars of fraud. Well, lord, kindly have a look at page 445 of the plaint ones. Well, lord, these are all recorded in my lord's order. When lordship had passed the ad interim order, there is a completion certificate, which my learned friend's client has issued, certifying that the entire work in respect of this contract has been completed. There is a taking over certificate, which has been issued by my learned friend's client, certifying that they have taken over the work which we have completed. And as per the contract, there is a defect liability period, which also got over. And now kindly see, my lord, the particulars of fraud. My learned friend submitted, I have misled the court in saying that the fraud, whereas I have committed fraud. What is wrong? Any one of them wrong, lordship throws me out of court. Defendant 2 was aware that the security being the bank guarantee have become void on and from 11 June 2022 after defect liability period was over.
Yes.
What submission does he make on this? Nothing.
Lordship, can I reply to this?
I did not interrupt. He does not have the guts to even annex the plaint and refer thereto. He has not annexed the plaint because, my lord, these are staring. I'll come to the arbitration clause. The defendant number 2, while calling upon the plaintiff to keep the performance guarantee extended, even after issuance of taking over certificate and completion certificate, always intended to unjustly enrich itself. Why are you asking me to keep it extended when, my lord, taking over certificate has been given and this has been given? That if you don't extend, I'll encash it.
The purported request for extension not due to any performance issue, but on the pretext of case decision pending. Their management is unable to close this contract, therefore their decision is pending, so I have to continue extending the bank guarantee. Well, it's from A, B, C, I can read all the particulars, and as in a demurrer action, the plain statements are to be deemed to be true and correct. They have not, my lord, filed any opposition to this application, interlocutory application. They have chosen not to deal with these allegations and have come up with this. So, my lord, on the face of it, and my learned friend started his submission, not a single allegation, my lord, dealing with any of this.
Yes.
And my lord's order has recorded all this. When my lord, we had moved at the ad interim stage ex parte, my lord, I am aware of my responsibility. And just to say from the bar casually that I have misled the court, I take it very seriously. So, my lord, none of this, and my lord, in fact, he cannot show any non-compliance pertaining to this contract. Now, my lord, the next argument, my lord, kindly see 478, my learned friend referred to. So, at best, what he is trying to say, if he relies on this, that I am invoking the bank guarantee not because of any dues in this contract, but some other contract where some third party is there. PowerTech.
That is he rely upon.
Yes.
4.2.
Any other contract.
44.
My lord, assume for a moment, my lord, my submissions are twofold. Firstly, my lord, it's a joint venture, it's a different entity. He can't have, it's not, my lord, relating to me. I am only a constituent, it's also a joint venture company. That's my first submission. Assuming for a moment he is entitled to deduct from any other contract. The bank guarantee does not permit. Kindly see the bank guarantee. And my lord, it is well settled that, my lord, bank guarantee can only be invoked in terms of the contract. My lord, 441 of the plaint, I read the bank guarantee, my lord.
441 of plaint.
Yes, my lord.
Give the plaint. Second one, third one. Page 414.
That is why the fraud guarantee is saying you have to fail to perform the above mentioned contract. It is specific.
Page 440.
441.
Yes.
440, the bank guarantee starts. Kindly see the bank guarantee at the second paragraph at 441. We, the undersigned Allahabad Bank Industrial Finance Branch, waiving all objection and defense under the aforementioned contract, hereby irrevocably and independently guarantee to pay on your first written demand an amount of up to 2 crore 44 lakhs and odd. Then, my lord, very important, against your written declaration that the contractor has failed to duly perform the aforementioned contract.
Yes.
So, my lord, you are giving a declaration that I have failed to perform this contract.
Yes.
And your own case is that the dues are pertaining to other contracts. If this is not fraud, what is fraud? I invoke the bank guarantee saying that dues under the aforementioned contract is payable.
Yes.
And all the submissions made is PowerTech, their public money, some other contract, joint venture, my lord, catching the nose the other way around.
Yes.
I don't know what will be a better case of fraud if this is not fraud.
Yes.
And my lord, there is no dispute after the completion certificate, the takeover certificate, defect liability period is over. Why should I keep the bank guarantee alive? And as per the contract, my lord, they are to return the performance guarantee after the defect. That's my first ground of fraud. And my lord, lordship has noted in my lord's order of 2nd August 2024. I can understand my learned friend referring to the order what we had submitted on the basis of which lordship had passed the injunction, pointing out a single sentence that I have misled the court. He brings in complete new facts which are nothing to do with this contract.
Even though Mr. Chaudhary, okay, this is as per you, your contract is over, but they are extending the so and so, not taking the plea with regard to the other contract. It is the fraud, whatever it may be committed. So whether this cannot be decided by the arbitrator.
No, well, I'll show that. Arbitration, I have a complete answer. Well, arbitration is a two-tier clause.
Correct.
There is a dispute resolution board. If the dispute resolution board has to be constituted within 28 days of entering into the contract, if the dispute resolution board fails, then you go to the arbitrator.
Correct.
Specific averment in para 40 of the plaint. Kindly have a look. My learned friend doesn't place it. I have not suppressed anything. 41 of the plaint. Did my learned friend say that there is a dispute resolution board which was constituted? If the first stage does not go, how will the second stage come? And he does not place the clause relating to dispute resolution board. Para 41 of the plaint. The dispute resolution clause contained in the said contract, inter alia, envisages arbitration only in respect of those matters which have been earlier referred to the dispute resolution board, DB, and only to the issues in respect whereof the decision of DB had not become final and binding. In the instant case, no dispute board or DB was appointed by the date specified in SCC, that is 28 days after the effective date. The absence of a DB therefore renders the dispute resolution clause under the said contract inoperable and invalid. Consequently, the condition precedent to arbitration not being satisfied, the arbitration agreement also becomes inoperable. Well, I would have gone for arbitration, he would have taken out a section 16 and would have said that this is not valid. And Lordship will see the dispute resolution board clause. Well, at 141 of my learned friend's application, volume 2. He doesn't place this. Because this is also part of their GCC. He refers to what suits him. He doesn't place this. And when it is specified in the plaint, and he is saying that I have misled. Dispute. Any dispute or claim arising out of or in connection with this dispute board agreement or the breach, termination or invalidity thereof shall be finally settled by institutional arbitration. Now, my lord, what is this dispute board agreement? My lord, Lordship will find that in the previous page. Sorry, I'm sorry, my lord, next page. My lord, specific issues what can be gone into by the dispute board has been mentioned. And then, my lord, Lordship will come to the arbitration clause which my learned friend relied upon. Which is, my lord, page 479. Arbitration. I am sorry, my lord, kindly first come to 477, then I will come to 479.
Yes.
I am sorry, my lord, this is 291. Yes. Beloved, my learned friend referred to the arbitration clause which is mentioned. 177. I am grateful. In the special condition of contract, there also there is reference to dispute resolution.
Yes, 177.
Yes.
Clause 18.
Yes, now kindly see how clause 18 starts. He ignores that. Because the first question Lordship would have asked, what is DB? DB shall be appointed within 28 days. DB shall be 3 members. List of potential DB members is none. Appointment, if not agreed, to be made as per 45.2. Then, my lord, with as per GCC, if the DB decision fails, then we come to this. So he only reads this without going into the and the plaint is categorically stating that.
Yes.
And my lord, lordship will see clause 13.3.3 page. But I'll give you a lordship the page. Yes, my lord, it should be 145. But why we say in the fraud that the security has become null and void? But lordship will see GCC 13, the clauses supplement read with the following. Then 13.3.2 is performance security shall be in the form of bank guarantee as per form included in section 6. I have already shown, my lord, how the bank guarantee reads. Only, my lord, you have to declare that there is a claim under this contract, not any other contract. And then, my lord, kindly see 13.3.3. Performance security shall not be reduced on the date of operation and acceptance. Then, my lord, the next para. The security shall become null and void or shall be reduced pro rata to contract price or a part of facility for so and so after completion of facilities or 365 days after operational acceptance.
Yes.
Therefore, my lord, that bank guarantee has become a nullity as per the contract. And you are trying to encash a void document suppressing all these facts and alleging that I have misled the court. In fact, my lord, why I say, my lord, when we had approached your lordship, lordship would recall I had informed the bank also that this has already been worked over. But my lord, bank, my lord, lordship knows how their officer was stationed and all that I am not repeating. My learned friend categorically gives a sermon that they have duly secured it and shown their bona fide. Bona fide was secured under the threat of arrest. Let my learned friend not forget that. And my relief in the plaint is declaration that the extension of bank guarantees are vitiated by coercion, declaration that the bank guarantee is liable to be adjudged null and void, and delivery and cancellation of the bank guarantee. This, my lord, can't be a subject matter of this because, my lord, I can understand my learned friend showing one dispute pertaining to this contract. Bank guarantee cancellation, bank guarantee, my lord, lordship is now aware, a separate contract between me and my bank. Therefore, my lord, the pleading is that so far as me and my lord defendant 2 is concerned, that is my learned friend's client, there is no dispute whatsoever. You have accepted the contract, you have given me a completion certificate, you have given me a taking over certificate, and as per the clause, after 365 days of taking over certificate, the bank guarantee is void. In spite thereof, you are trying to invoke that.
Yes.
And my lord, this bank being party to the fraud, my lord, I have come and filed a suit. Because, my lord, I cannot make bank a party in the arbitration clause, in the arbitration proceeding. And there is no dispute vis-a-vis the main contract. For what will I go and invoke the arbitration?
Yes.
Because this is a fraud where the document itself has become void. The bank shouldn't also have released it. But my lord, bank played safe. They said, no, I have a demand, I have to release it. And lordship is aware of that. So, my lord, my submissions are twofold. Firstly, my lord, this is not an application under section 8. This is order 7, rule 11. Fundamental principle of order 7, rule 11 is the averments made in the plaint are deemed to be true and correct. The plaint has not only disclosed what is perceived dispute resolution clause, but has also said why it has not been invoked. Unfortunately, my learned friend does not even refer to that. Thirdly, my lord, so far as arbitration is concerned, there cannot be a dispute arising out of the contract. It's a dispute for the invocation of bank guarantee, because on his own submissions, the claim doesn't pertain to this contract.
Okay.
So, assuming for a moment, my lord, whatever my learned friend said today is correct, can he go and say that before the arbitrator that I have a due for power tech? Is power tech a party in this?
Yes.
What will the arbitrator decide? So, my lord, under those circumstances, my lord, kindly dismiss it.
Yes.
And no affidavit in the main proceeding on merit. And my lord, all those particulars of fraud, he doesn't even deal with it even while placing it. What wrong have I done?
Yes.
Those are my submissions.
That's all.
146, my learned sir told.
Just a minute, my lord. My lord, the judgments are well settled. My lord, the judgment which was shown, my lord, kindly come to only one judgment, my lord. Lordship's judgment has been referred to, which is in Suresh Dhanuka.
Yes.
Suresh Dhanuka, my lord, section 8 was allowed. In fact, my lord, I had appeared, but though on the losing side. I don't know if that inspired my learned friend to select this.
No, Lord. No, sir. Not at all, sir.
My lord, this was over here. Kindly see, my lord, this is my lord's view.
That was the content. That was the.
My lord, there is no, it is not a dispute is not pertaining to third party. Here, my lord, they are saying that whatever claims they are having, it's for Power Tech, which is a joint venture partner in some other contract where I have allegedly, my lord, I have allegedly not paid them or not done the work. They have their remedy. They can themselves file an arbitration in that if they are so advised. That can't be a ground, my lord, to encash the bank guarantee which has already become void. You were supposed to return it after the 1 year from the completion or taking over certificate.
Yes.
Lord, this application has no merit, my lord. It should be dismissed.
Lordship, at page number 146 of my paper book.
Yes.
The clause number 13.3.3.
Correct.
It was read half. There is a proviso also. The security shall become null and void, 146.
Correct.
Or shall reduce pro rata to the contract price of a part of the facilities for which a separate time for completion is provided, 540 days after completion of facilities or 365 days operational acceptance of facilities.
Correct.
Which occurs first, provided. However, that if the defect liability period, Lordship, the tender was under deciding of liquidated damages. There are certain liquidated damages also we have to decide. And there's a defect liability period that was ongoing. And certain liquidated damages we have to see on the site. Our officer has to go on a site, check it, that if there are any liquidated damages or not. And after settling of a liquidated damages, the final amount is to be decided and tender is to be closed. And then the bank guarantee is
released. Where is a claim? Under the liquidated damage, you are.
It was not yet decided. It was not yet decided. But in between, what happened?
That's why before liquidation of before the revocation of the bank guarantee, now you have taken the plea of the
no.
The liquidation damage. If the liquidation damage, what is the duty of the authority? Authority has to first.
I tell you. Lordship. The reply to this is, Lordship, meanwhile all this was happening, the another tender, which they cannot shy away, they have signed it. And it's a JV partner. In that tender, it is very well written over there. It can be recovered from any other contract. It is a written thing. I am not shying away. It is a written thing over there. And after that only, invocation and operation by that order, by that line, we stopped and encashed the bank guarantee.
Show your notice for invocation. Show your notice of invocation on that clause you have invoked. Show your notice on invocation.
Lordship.
And one thing you also keep it in mind, you filed an application for rejection of plaint, but not dealing with the averments in the application or the plaint. That is also be keep it in mind under Order 7 Rule 11. And second thing, you also keep it in mind, the application which you have prayed for, you have totally argued the matter for the last 1 hour for appointment of arbitrator under Section 8. And initially when you started the argument, this court has warned you about the prayer. That also.
Yes, Lordship. Yes, Lordship. Lordship, just I want in this, my limited prayer is that by the section 8, the matter can be referred to an arbitrator.
But that's what I'm telling. That's what I'm telling. Kindly come to the prayer of the application, sir. This is the original side of the Calcutta High Court.
Yes, Lordship.
And you have only prayed under Order 7, Rule 11 for rejection of plea.
Lordship, the arbitrator
Order
will
7,
be
Rule 11, under Order 7, Rule 11, you have not dealt with the affidavit with regard to leave aside the suit, whether I am not going into that, but you have not dealt with the application in which the injunction was passed, where they have prayed, where they have
yes.
specifically taken the ground of fraud.
Lordship, that affidavit
How
I
it
will
can
file.
be, how this court can dealt with.
Lordship, that affidavit I will file. I require time for that. I will file the affidavit for that.
After hearing, that's why initially
Yeah, Lordship.
This court has.
Yeah, your Lordship is very much correct for that. Lordship in the starting only asked me for read the prayer.
Correct.
So Lordship, I for if the Lordship has a point for that, I will file an affidavit regarding to that.
Court is not telling file affidavit, but now you are arguing to complete your argument on merit. 1 hour you
Yeah,
are.
1 hour has Lordship.
Anything further to add?
No, Lordship.
So offering for the plaintiff. So offering for the defendant. Plaintiff has the defendant number 2 has filed the present application being GA Com 3 of 2024. वाला complete कर मिला ठीक है चलिए
Lordship, one thing I just want to also let you know that it is subject to the Jaipur's jurisdiction. Lordship, arbitrator can be appointed over there, but just simply as an argument, I'm saying that
but
it can be.
You're not argued with regard to this forum selection clause. You're also not argued the forum selection.
No, Lordship, in my application, it is there. My application, it is there.
It is there, but you're not argued on that.
Lordship, my senior said that is a forum shopping. I am over it that I made an argument and he was making the reply to the 3 arguments. It's a forum shopping also in Jaipur only. Otherwise, I would have not moved for the 711 application. I just want that the matter can be referred to the arbitration and they can file and get the arbitrator appointed.
They are not agree. Otherwise, why I could have been hear you directly within 2 lines. If both the party consent, this court can pass an order. But the other party, the plaintiff is not ready for the arbitration.
But Lordship, there is a very much clear as per section 8. By going through all the judgments, I'm not relying on the one judgment. There are various judgments also, which clearly says that there is an arbitration clause and a valid agreement.
Clause is correct.
And there's not a big fraud. There is not a fraud as such.
The court is not denying what is in the black and white, but only court has to see whether the clause is applicable in the present suit or not. First thing. Second thing, this court, unless and until both the parties is not agreed, this court cannot appoint the arbitrator. Then with regard to the forum selection clause, you have not shown, you have not argued, though you have pleaded, you have not argued, the other party has not given the reply to that. And this court has also not option to go into that aspect also.
Lordship, but I argue right away regarding that.
Present application praying for being GA Com 3 of 2024. Praying for rejection of plaint. Praying for rejection of plaint. The counsel for the plaintiff, counsel for the defendant has submitted that the context between the plaintiff and the defendant having the arbitration clause, which reads arbitration clause, having the arbitration clause in clause 55 of the GCC, and as such, this court is not having the jurisdiction to to proceed with the suit filed by the plaintiff and prayed for referring the matter to the arbitrator. Full stop. Counsel for the defendant number 2 submits that as per GCC 45.2 within bracket small b, the contract with contractors being nationals of employer's country, semicolon, any dispute, controversy or claim arising out of or relation to this contract or breach, termination or invalidity thereof, shall be settled by arbitration in accordance with the Indian Arbitration and Conciliation Act 1996 as amended from time to time, and the rules made thereunder. The place of arbitration shall be at Jaipur. Counsel for the defendant submits that. Counsel for the defendant submits that. As per clause 44.2.6 of the agreement entered between the parties, it is mentioned that if such excess is greater than the sums due to the contractor under GCC subclause 44.2.5, the contractor shall pay the balance to the Nigam, and if such excess is less than the sum due the contractor under GCC subclause 44.25, Nigam shall pay the balance to the contractor. For facilitating such payment, the Nigam shall encash the bank guarantees of the contractor available with the Nigam and retain such other payments due to the contractor under the contract in question or any other contract that the Nigam may have with the contractor. The counsel for the defendant further submits that the correspondences made between the parties, it is crystal clear that the plaintiff and the power tech engineers are the joint venture partners. Counsel for the joint venture partner, and as such the clause 44.2.6 is applicable to the plaintiff. Counsel for the defendant further submits that the plaintiff has filed the present suit by suppressing all the facts and obtain an interim order without completing the contract work. He submits that the dispute between the plaintiff and the defendant plaintiff and the defendant number 2 is covered under the arbitration clause, and as such the matter is to be referred to, and the parties are referred to the arbitration. The counsel for the defendant in support of his submission has relied upon the judgments reported judgment in the case of Avital post you take down 1, 2, 3, 4, not entity, only how you can mention the citation you have to take. Mention name, citation, so and so, so and so. Full stop. Perfect. Then counsel for the defendant referring the above mentioned judgments and submitted that the case of the defendant is squarely the judgment counsel for the defendant to submits that the judgment referred by the case of the defendant number 2 is squarely applicable to the judgments referred by the defendant number 2 and prays for referring the matter to the arbitration. Full stop. Per contra,
Lordship, my one point was also left in the plain section, point number 41, para 41, that arbitration is not in between the Indian bank. That
judgment se pehle na counsel for the defendant further submits that in the plaint in paragraph 41, the plaintiff has cleverly made an averment that the plaintiff is having a composite cause of action both against the defendant number 1 and 2, being required to seek relief only against the defendant number 2, but also the defendant number 1. Counsel for the defendant number 2 submits that only to safeguard and only to avoid the clause of arbitration, the plaintiff had the knowledge that the case of the defendant is covered under the Arbitration Act, the plaintiff has made the defendant number 1 bank as party to avoid the arbitration proceeding. This is your submission?
Yes, Lordship.
Then proceed. Number niche आ जाएगा. Per contra, learned counsel for the plaintiff submits that the defendant has not read the paragraph 41 of the plaint, wherein the plaintiff has categorically disclosed that the dispute resolution clause contained in the contract envisages arbitration only in respect of those matters which have been earlier referred to the dispute board. But in the present case, though the defendant number 1 today filed an application and praying for referring the matter to the arbitration, but the defendant number 2 has not shown defendant number 2 did not show any document that the dispute, if any, between the plaintiff and the defendant number 2 was referred to the dispute board. He further submits that
no dispute board was constituted within 28.
Lordship, they have to make a plea before a dispute board.
Correct.
They haven't made a plea before a dispute board.
I will record. He submits that. Where is that clause? Where is that clause? Dispute board.
141, my lord. 141, 142. Lordship.
Counsel for the plaintiff has referred clause 9 of the agreement, wherein it is categorically mentioned that any dispute or claim arising out of or in connection with the dispute board agreement or the breach, termination or invalidity thereof shall be finally settled by institutional arbitration. If no other arbitration institute is agreed, the arbitration shall be conducted under the rules of arbitration of the International Chamber of Commerce by one arbitrator appointed in accordance with these rules of arbitration. Learned counsel for the plaintiff submits that though the defendant is praying for referring the matter to the arbitration, but no board was constituted by referring the dispute to the board. Counsel for the plaintiff has also relied upon the dispute board guidelines under which the board is to be constituted and submitted that unless the board has not been constituted, it is not proper for the defendants cannot pray for referring the parties to the arbitration. Learned counsel for the plaintiff has further relied upon the clause GCC 13.3.2, wherein it is mentioned that performance security shall be in the form of bank guarantee, as per form included in the in section 6 within bracket employers requirement, bank guarantees and certificate bracket close, which shall be acceptable to the purchaser. Full stop. In case bank issuing the bank guarantee is located outside India, it shall have the correspondence bank located in India. He has further relied upon the GCC 13.33 and submitted that the performance security shall not be reduced on the date of the operational acceptance and shall be valued specified. He further submits that as per the said clause, the security shall become null and void or shall be reduced pro rata to the contract price of the part of the facilities for which separate time of completion provided 540 days after the completion of the facilities or 365 days after the operational acceptance of the facilities. Counsel for the plaintiff submits that while passing the interim order, this court has considered the order there, interim order.
2nd August order.
Second order. Counsel for the plaintiff submit that while considering the submission made, while considering the while considering the prayer of the plaintiff for grant of interim order, this court has considered that the defendant number 2 has issued the completion certificate to the petitioner notifying that the facilities have been completed on 28th of March 2021 to 28th March 2021 and in accordance with the terms of contract, full stop. He further submit that on 8th of April 2021, the defendant number 2 also issued a letter to the senior account officer for release of the 10% contractual retention of the total on pro rata X work amount of supply the service part upon issuance of the completion certificate, and accordingly the plaintiff has received the 10% amount in terms of the completion certificate. Counsel for the plaintiff further submit that the defendant number 1 and defendant number 2 had also issued taking over certificate on 11th of June 2021, wherein it is mentioned that as per the work order, clause number 25, taking over certificate was issued on successful completion and commissioning of the said line on 28th of March 2021. Full stop. Counsel for the plaintiff submits that counsel for the plaintiff submit that the counsel for the plaintiff has referred paragraph 32 of the plaint, wherein the plaintiff has categorically pleaded the fraud played by the defendant number 1 and defendant number 2 in connivance with the defendant number 1, and as such the allegation of the fraud is to be considered by this court in the present proceedings. Full stop. Heard the learned counsel for the respective parties peruse the material and learned counsel for the defendant counsel for the plaintiff submit that the judgment relied by the plaintiff is settled possession of law with regard to referring the matter to the arbitration, but all the judgment referred by the plaintiff defendant number 2 is distinguishable from the facts and circumstances of the present case, and submits that in the present case work has been completed, the completion certificate has been issued. Subsequently, the defendant number 2 has committed fraud upon the plaintiff in connivance with the defendant number 1, and thus the judgments are not applicable in the present case. Heard the learned counsel for the respective parties peruse the materials on record and the judgment relied by the plaintiff.
Lordship, my recording was that in the precedent condition of dispute resolution, page 178, this was also left.
What?
Page 178.
What is your submission?
Lordship, there is no precedent condition of dispute resolution.
Heard the learned counsel for the respective parties peruse the materials on record and the judgment relied by the defendant. Full stop. As regard the availability of the arbitration clause in the agreement, there is no dispute. The plaintiff, the defendant number 2, has filed the present application being GA Form 3 of 2024, praying for following relief, semicolon, inverted comma. Hence, in the aforesaid facts and circumstances, comma, it is most humbly prayed that your lordship would graciously be pleased to reject the plaint of the instant suit in limine with exemplary cost, and to pass such other orders as your lordship may deem fit and proper for the ends of justice. Inverted comma close. In the present application, the defendant has prayed for rejection of the plaint. It is settled law for at the time of hearing of the rejection of the plaint, comma, the contents of the plaint is to be taken as true. The plaintiff has filed the plaint as well as the interim application. In both the proceedings, comma, the plaintiff has raised the point of fraud. The defendant defendant number 2 choose not to file either written statement or affidavit in opposition with regard to the interim application. So remain the facts narrated in the plaint as well as the application remains undisputed. Remains undisputed.
Lordship, my
Now the court has to see whether though there is no prayer made in the application for referring the matter to the arbitration, even though taking into consideration of the submission made by the plaintiff, the matter can be referred to arbitration. The dispute, the plaintiffs, the defendant number 2 contends that as per the clause in the GCC, the matter is to refer to the arbitration. The defendant has taken the two specifically, that is first, the dispute board. Before referring the matter, a dispute board is to be constituted. Defendant number 2 has not shown any document by filing this application on affidavit whether any dispute board was constituted or the matter was referred to the dispute board.
Lordship,
Full stop. The learned counsel for the defendant number 2 submits that the dispute board as referred in the agreement in the contract is not a mandatory provision. And as such, this court, and as such, it cannot be said that the arbitration clause cannot be invoked before the dispute board has been constituted. This court is not, and this court has not accepted the contention made by the defendant, as per clause 9 of the contract, the dispute refers as follows. Page 141, this one. Page 147, mark portion, 141, full stop. In clause 9, the dispute board guidelines has also been mentioned. As per the dispute board guidelines, there are altogether 8 guidelines and sub guidelines have been fixed. If we taken into consideration this dispute and the guidelines is not mandatory, why the defendants have mentioned the guidelines of the dispute in the contract? If this court accept the contention of the defendant that the dispute is not mandatory, though it is also a clause of the contract, then this court also can say the arbitration clause is also not mandatory. Not mandatory. The party cannot choose which clause is mandatory and which clause is not mandatory, though the parties have entered into the contract by open eye. Secondly, the dispute arose, and the cause of action arose for filing the suit for revocation of the bank guarantee of the plaintiff. Admittedly, as per the document relied by the plaintiff, the work which has been awarded to the plaintiff, the plaintiff has completed the work and concerned authority has given the certificate of the completion, as well as taking over the work by the defendants. During the argument, the learned counsel for the defendant has stated that there is a liquidated damage which is required to be recovered for the plaintiff. But on query, the defendant has not produced any document to show that any notice or any demand was placed to the plaintiff with regard to the liquidated damage or any amount which is recoverable from the plaintiff. Full stop. The counsel for the defendant has relied upon GCC 13.3.3 of the proviso clause wherein it is mentioned that if defects liability period has been extended and any part of the facilities pursuant to the GCC subclause 27.8 hereof, the contractor shall issue an additional security in an amount proportionate to the contract price of that part. If this court accept the contention of the defendant number 2, but this court cannot accept the contention of the defendant number 2 as there is no document or evidence shown by the defendant number 2 to say that the defendant has asked for the liability period is to be extended or any liability is lying with the plaintiff, full stop. Considering the above, this court did not, full stop, as in the, though the plaintiff has, though the learned counsel for the defendant has submitted that the jurisdiction is of the Jaipur, is the court of Jaipur, but the learned counsel for the defendant has not argued the matter with regard to the forum selection clause. Considering the above, this court find that the application filed by the defendant does not having any merit. Accordingly, the same is dismissed.
Deeply appreciated.
Next.
Item number 9 of the non-motion.
I beg to appear, my lord. My lord, this is an application, my lord, seeking amendment. My lord, at the time of filing, my lord, some years in intestacy, my lord, was left out. My lord, now they have consented and they are required to brought in the record. That is why this amendment has been filed in the main application. And my lord, one spelling of one attesting witness was wrongly typed out. For that correction, my lord, this application has been made.
So you want to amend the, delete the prayer B, C and D? A, B and C?
Yes, it was not required because all are given consent.
All have come, have
All
filed.
It is annexed with my application and I prayed for my lord, direction upon the department also to, my lord, to accept those consents.
Incorporate in the.
Incorporate and
Where
accept.
is our PLA? PLA का है?
I have annexed the PLA application also.
Acha. Where is the legal details?
Yes, my lord. Kindly come to page 42. No, I have given in my proposed application. I am giving, my lord. Page 11.
No, in the original,
Yes,
in the original probate application, you have not mentioned, only two you have mentioned.
Only two. Page 10.
Tarubala and Arijit.
Yes.
Now you have mentioned all.
All.
And all have come forward.
Come forward and
they
my
have
lord.
given this.
And my lord, those died, my lord, I have annexed their death certificate also.
Whose?
Torubala and Orijit.
Tarubala, Arijit died.
Ovijit. This name would be, my lord, Ovijit instead of Orijit.
So one is the Avijit is the son of
deceased.
That Tarubala.
Torubala was the widow.
No. Kindly come to the proposed page 11.
Yes,
proposed application.
Yes, Ovijit was son.
Avijit was son of the testator.
Testator. And my lord, in para 5.
That is Arijit.
Ovijit.
Arijit is Avijit. Okay, then Shabrani Shaha.
Because Ovijit died in the meantime, my lord, I have said, my lord, under column 1, my lord, died on 8th of March 2024.
Arijit
page,
died?
Yes, page 11. I have annexed the death certificate.
Where you mention? Deceased was married.
Column under column 1, my lord. Ovijit Shah, son of
died on 8 March.
Yes.
8 March. So this A and B are their legal heirs.
Legal heirs.
That is this wife.
Wife
and son.
Daughter.
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 And second is
Daughter of the deceased.
daughter of the deceased.
Another son. Third is another son.
No, daughter of the deceased means the testatrix.
Testator.
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 So you are not mentioned her name in the original PLA.
Original.
And Abhijit name was not there.
Not there.
So what about the Tarubala?
Tarubala, my lord, in para 5 I've said, my lord.
Tarubala shall predeceased.
Predeceased. 2000. I have annexed the death certificate. They have given all
She
the.
is the wife of the Nikunja. Okay.
And other prayers in the are, my lord, consequential to the reliefs.
Succession suffering for the petitioner. The petitioner has filed the present application for amendment in the probate application. Counsel for the petitioner submit that initially when the plaintiff petitioner has filed the present application for grant of probate, the petitioner has mentioned only two legal heirs, that is Taru Lata Shaha being the wife of the testator and Arijit Shaha, but the name is to be corrected as Avijit, A-V-I-J-I-T, Avijit Shaha being the son of the testator. Counsel for the petitioner submit that during the pendency of this application, the petitioner came to know that the Taru Lata Shaha being the wife of the testator was predeceased to the testator who died on 18th May 2000 and Avijit Shaha died on 8th of March 2024, leaving behind his wife Sarabani, S-R-A-B, Sarabani Shah, and daughter Anusha, A-N-A-S-U-A, Anusua Shah, A-N-A-S-U-A, Anusua Shah. Counsel for the petitioner further submit that the petitioner also came to know that the testator had other one daughter and died, leaving behind another one daughter and one son, namely Namita De and Biswajit Namita De Sarkar, and Biswajit Shaha. Counsel for the petitioner submit that now the petitioner intend to bring all the legal heirs of the testator as well as the legal heirs of Avijit Shaha on record by way of amendment in the probate application, as well as police. Counsel for the petitioner further submit that now all the legal heirs have submitted their affidavit of consent, which is enclosed along with the present application, and prays for allowing the petitioner to file the original affidavit of consent of all the legal heirs as mentioned in the proposed amendment in paragraph 5 be taken on record of the PLA number 258 of 2023. Counsel for the petitioner further submit that as all the legal heirs of the testator have filed their affidavit of consent, accordingly, he prayed for deletion of the prayer A, B, and C of the original probate application. Had the learned counsel for the petitioner.
Another thing, my lord, in the affidavit of the attesting witness, that name Orijit has been wrongly spelled out. It would be Ovijit. That for that reason also amendment has.
Where?
Page 32 kindly. Last line, bottom. Somewhere it has been.
Achha. Counsel for the petitioner further submit that in the affidavit of the attesting witness.
As also, my lord, a declaration in the petition.
In the affidavit of the attesting witness and in the declaration of the probate application, name of the son of the deceased have been inadvertently recorded as Arijit instead of Avijit, A-V-I-J-I-T. And as such, in the in the affidavit of the attesting witness as well as
declaration and petition.
declaration and
Probate petition.
Declaration in the probate petition.
And also for the probate petition.
Oh, that already recorded. Declaration and in the probate application. The name of the son of the testator is to be corrected as Avijit Shah instead of Arijit Shah.
Yes, my lord.
Had the learned counsel for the petitioner perused the application and the proposed amendment, this court finds that the amendment as sought for by the petitioner is formal in nature and will not change the nature and character of the application. Accordingly, prayer
A to J, my lord. All are consequential.
Prayer A to J of the master summon is allowed.
Grateful, my lord. My lord, need not to be drawn up, my lord. Need not to be drawn up.
Huh?
Need not to be drawn up, this order, my lord.
That cannot be. The GA number 1 of 2024 is disposed of.
My lord, unless
the
my lord
department is directed to take appropriate steps for amendment. After the amendment is carried out, the petitioner shall re-verify and reaffirm within a period of 1 week after the amendment is carried out.
My lord, I will do that, my lord.
Within 1 week after the amendment is carried out.
My lord, within 2 weeks, because my lord, holidays is coming.
2 weeks. GA number so disposed.
And order need not to be, my lord, drawn up, my lord.
Though this order is only with regard to the amendment of the application of the probate application, and as such it is not required to be drawn.
Grateful, my lord. Grateful.
My lord, I am for the plaintiff, my lord, petitioner in this matter, my lord. My lord, there is some defect in the probate application regarding the address of the testator. In this regard, we have filed an amendment application GA number 1 of 2024.
That was dismissed.
Yes, my lord, with the liberty to
filed
file
new one.
afresh.
Where is that?
I will.
It has come? No.
No, my lord.
You
I
have not
will.
filed.
No, my lord. I will do the same within next week, my lord.
You pray for time.
Yes, my lord.
As per the prayer made by the counsel for the petitioner, the case is adjourned. Let the matter appear on 8th of January 2025.
Grateful, my lord.
Worship, I am appearing. Your Worship, I am appearing on behalf of the petitioner executor in this matter. By an order dated 28 November 2024, Your Lordship has been pleased to direct the department to issue testamentary suit number, but the same could not be done. So I'm praying for 2 weeks time so that the order can also be drawn up. I had already filed a request on 2nd December only, but the order has not been drawn up and testament.
Made the request to the department.
Yes, I had also issued a letter to the registrar as well.
When?
On 5th December.
6th December. As per the order passed. So appearing for the you are
I'm for the caveator.
So appearing for the petitioner. So appearing for the caveator. By an order dated 28th of November 2024, this court has converted the PLA 80 of 2021 to the testamentary suit and directed the department to provide the testamentary number, but the same has not been complied with. Accordingly, the department is directed to comply with the order dated order dated 28th of November 2024 by providing the testamentary number within a week from date. Release the matter on 9th of January 2025. Next.
My lord, this is my application for grant of letters of administration with will annexed, my lord. In the
with will.
With will. Because my lord, in the will, my lord, no executor has been appointed.
How many legal heirs?
Two legal heirs, they have given consent, my lord.
Who is
One
the
of
petitioner?
my lord, it is Salt Lake property.
Huh?
It is Salt
Salt Lake.
Uh,
What is the fees fixed under the notification?
5 lakhs
Per kata.
per kata. It is running from 2012. It has not been
Not
enhanced.
that's why I'm asking. Still it's going on.
5 kata. And one of the heirs, my lord, is the attesting witness. He has approved the will by filing the, my lord, affidavit and declaration.
Yes. Who is the testator? Animesh Banerjee.
Animesh Banerjee is the testator.
Is the testator.
Yes, my lord. And the
He died on 16/12/19.
yes, my lord.
How many legal heirs?
2, my lord. Page 4, my lord. Para 5.
Page 4. 2 legal heirs.
Yes.
Daughter.
Two daughters.
Both daughter.
Daughters.
And they have filed affidavit.
Yes, my lord.
Where is that? And the wife is
Died
predeceased.
predeceased, my lord.
Predeceased.
Death certificate annexed, my lord.
Yes. Where is the affidavit of the attested? The daughter
Daughters, my
Surita
lord.
Banerjee.
It is in the file, my lord.
देखना ये सुरीता Banerjee.
Rinka and Surita. And one of the daughter is, my lord, attesting witness. Surita is the attesting witness also.
Who has filed the affidavit? Surita filed the affidavit.
Attesting witness? Yes.
No independent witness.
Yes, my lord.
So-and-so appearing for the plaintiff petitioner. The petitioner has filed the present application for grant of letters of administration. For grant of letters of administration of the last will and testament dated 21st of June 1993. Counsel for the petitioner submitted. Though the testator Animesh Banerjee has executed his last will and testament on 21st of June 1993, but in the said will he has not appointed any executor of the will. Accordingly, the petitioner, being the beneficiary, has filed the present application for grant of letters of administration. The petitioner says that the testator died on 16/12/2019, leaving behind two daughters, namely Surita Banerjee and Rinka, R-I-N-K, Rinka Banerjee. He submits that the wife of the testator was predeceased to him, who died on 24th of April 2019. He submits that both the daughters of the testator have filed their affidavit of consent, stating that they have no objection if the letters of administration is granted to the petitioner. Counsel for the petitioner submit that in the will there are two attesting witnesses, out of which one of the attesting witness, three attesting witnesses, out of which one of the attesting witness, who is also one of the daughter of the testator, has also filed an affidavit as attesting witness. Counsel for the petitioner submit that the petitioner has proved the will and is entitled to, and the petitioner is entitled to get the letters of administration. Had the learned counsel for the petitioner perused the original will dated 21st of June 1993, death certificate of the testator, death certificate of the wife of the testator, affidavit of consent of both the daughters, and affidavit of the attesting witness. It is found that both the daughters have categorically mentioned in the affidavit that they have no objection for grant of letters of administration to the petitioner. The attesting the attesting witness, who is one of the daughter of the testator, has being the daughter of the testator, has also categorically mentioned in a separate affidavit stating that the testator has executed his last will and testament in her presence and in presence of other two attesting witnesses while possessing good health and fit state of mind. Considering the above, this court find that the petitioner has proved the will and is entitled to get the letters of administration. In view of the above, the department is directed to issue letters of administration of the last will and testament dated 21st of June 1993, subject to furnishing the bond of rupees 5 lakhs with 2 sureties.
5 lakhs.
5 lakhs with 2 sureties. 2 sureties, and upon completion of all formalities.
Grateful.
At the time of grant of letters of administration, the copy of the will be made as a part of the letters of administration.
Grateful.
PLA number 77 is disposed of.
Next. This also, my lord, need not to be drawn up. Otherwise, my lord, there is long queue in drawing up. That is the difficult.
That is to be. Letters of administration is to be drawn up.
My lord, as per the rules, my lord, so far subject to the rules, my lord, this order need not to be.
Letters of administration, because
need not to be drawn up. I understand.
Interrogatory, I can understand. Which rule you are referring to?
Original side rule. Let me check, my lord. My lord, chapter my lord, 26, 16, chapter 6, chapter 16, rule, my lord, 23A, under serial number Roman 12.
23A, drawing of the signing a registrar or master. Every order made by the registrar or master shall, upon application, will draw up the office of registrar and signed by the office making the same, provided if by reason of absence of the officer and will not be signed.
The following orders need not to be drawn up unless otherwise ordered and
otherwise unrequired. Orders of extension are returnable.
Roman 12, my lord.
Roman 12.
Next page, yes.
Orders for grant of letters of administration of
Need not to be drawn up.
Why you want the exemption?
It is not need not to be drawn up. In the rule, it has been stated. Grateful, my lord.
As per the prayer made by the counsel for the petitioner, as per chapter 16, rule 23, capital A, within bracket Roman 12, the orders for grant of letters of administration need not to be drawn.
Grateful, my lord.
Yes.
Actually, this is my application for a conversion of a grant.
Conversion?
Yes.
For?
Probate to letters of administration.
GA?
GA1, Your Lordship. Kindly comes to page 4 of the GA1, 28th August 2024. I had been granted leave.
Department direct to carry out the proposed amendment and convert the application. Who is for the caveator?
Nobody.
Nobody. So why you
Probate
want
to letters of administration. There's some problem. I could not have.
So why you want to
proved it in
conversion?
It could not have been proved in Solent form.
Acha, probate to letters of administration.
Yes.
Why? No executor.
Attesting witness. There's some problem with the attesting witness of the will.
Where it is?
The will is not annexed. It is with the department. It was with the department. I have been told that the same person has signed 2 places as witness 1 and witness 2. That is why I could not have taken any risk. The application and the affidavit of assets, both of them have to be amended. And I've indicated that in red ink.
Where is the proposed amendment?
Proposed amendment is in red. Lordship comes to page number 5, starts page number 5 onwards. Comes to page 7, paragraph 5.
But why? Why you want?
Lordship, I could not have proved the will in probate court. I could not have proved the will in probate court. It has to be by letters of administration.
Why? What is the reason? You are not given the reason.
I stated the reason before the learned judge on 28th, but this honorable court on
Only stated that there is something.
on 28th August, pursuant to which my lordship was of the view that please convert it. I wanted to withdraw and file afresh.
So and so appearing for the petitioner. The petitioner has filed the present application for conversion of the probate application to the from the probate application to grant of letters of administration. Full stops. Consider the submission made by the counsel for the petitioner perused the application. Prayer A2 D of the master summon is allowed. GA1 is disposed of. Next.
14, my lord. I am for the petitioner, my lord.
I am for the defendant led by Ms. Devashree Dhamali, my lord.
Today is the date fixed for witness action, my lord. Your lordship.
My lord, the defendant did not want to proceed with this matter, my lord. This is the intimation letter.
File an application for discharge.
My lord, what has happened, my lord? There are two deceased. My lord, this is a joint will executed by the husband and wife, my lord. My lord, bequeathing properties in favor of two sons and two daughters, my lord, they get only some monetary benefits. My lord, one daughter has given consent. My lord, another daughter has filed caveat, and my lord, she is appearing on behalf of the another daughter, my lord. Now she is not willing to proceed with the case, my lord. But my lord, I am ready with my witness, my lord. My lord, issue has been framed already. But
My lord, it is written in Bengali language, my lord.
खाली अक्षर बैच बराबर. File in short affidavit otherwise.
Short affidavit. Okay,
Can you file?
No, my lord.
No.
No, not yet, my lord.
Where is your client?
No, my lord. My
Where
lord,
is your client?
my lord, my client is not present, my lord.
No, she can come and file an affidavit.
Okay, my lord.
Or you bring the English language letter.
As
It
your
will be
lordship.
interpreted. It will be interpreted by the interpreter of this court, my lord.
As
I
your
will
lordship.
accept your submission, then let the suit be go as a undependent.
Lordship.
Or otherwise, because already it was converted.
Lordship.
Discharge will not do.
This is contentious proceeding, my lord.
No, that's why. So it will go to as an independent now.
Lordship. I will file, my lord. Affidavit.
So suffering for the plaintiff, so suffering for the defendant. Counsel for the defendant submits that he has got a written instruction from her client that the defendant is not interested to proceed with the matter. Though the petitioner has handed over a communication made by the defendant to the learned advocate on record of the defendant, which is in Bangla language. Accordingly, the petition is directed to submit the translated copy of the said letter.
No, the petitioner, I am for the petitioner, my lord. My lord.
The defendant is directed to submit the translated copy of the said document. By 1 week, you will submit this translated copy.
Yes, my lord.
Or communication in English.
No, my lord. Within 1 week, I will try.
Within a week. Within 2 weeks. Within 2 weeks, list the matter on 8th of January 2025.
My lord, 8th
January.
Grateful to your lordship.
Yes.
No, my lord, if possible, my lord, can you give a shorter date, my lord?
Shorter vacation, if you're ready to come on vacation, the court will come and.
If your lordship direct, I can come, my lord. Yes. নামটা দিয়ে দাও নামটা দিয়ে দিস
Item.
I appear for the respondent in this application.
May it please your lordship, this is my application for revocation of grant on the ground that the legal heir has not been served. And the practice of fraud has been perpetrated at the time of filing of the petition.
It is completed?
Yes, ma'am.
Proceedings are complete. For the but that paragraph 9 of my application, I have quoted paragraph 4 of the probate petition.
GA1.
My lord, GA1.
Paragraph 9.
Paragraph 9 of my application at page 3.
Yes.
I have quoted what they have stated, the executor have stated at paragraph 4 of the application for probate, my lord.
Yes.
Your petitioner, in spite of his best efforts, could not trace out any legal heir or husband or on whom the said bequeathed property would have devolved had she died intestate. So it is the specific case that they could, if they could know of the legal heir, they could serve. Since they could not find any, they could not serve. My lord, kindly come to paragraph 66. Page 66, my lord, of this particular application. This is
What is your defense?
But threefold. One is the statement made in the probate application is that, my lord, I did not know about any other legal heir because the property belonged to my deceased husband, the late husband. Then, well, after his death, came to the testator. Then, after the testator's death, in accordance with the will, whatever is there. My defense is, my point is that why I was not aware what other relatives or what other legal heirs were there of the husband, of the late husband. That is why I could not serve, and that is why I made an application for publication of the gist of the for general citation. That publication was made; it was advertised, and after in view of in terms of this court's order, and thereafter they did not come with any objection or anything. That is point number one. Point number two is in the application in GA1, they have stated that that first they have to cross the hurdle as to why they did not approach this court when the publication was made.
Correct. No, second, what is the second?
Second is that in the application they have themselves stated that they had relinquished their right, if any, in respect of the bequeathed property is concerned. It's a categorical statement made when the testator was alive. They had apparently they had some discussions with regard to who this property would go to after her death, and they had particularly relinquished their rights, if any, in respect of the property. After relinquishing their rights in respect of the property, they cannot come seeking for revocation of grant of probate. That's point number two.
The relinquishment. So you had the knowledge prior to the will?
No, my lord, I did not. I am making this statement.
How you came to know with
That's what they have stated. That's what they have stated in the application. Okay. My first point is that they could have come before.
Third?
And third is there is no particular allegation that the will was executed under suspicious circumstances. Okay. But I've explained the circumstances in which the will was executed. It's a registered will. Okay. The lordship will decide.
My lord, if I go by their defense, that will be easier.
That's why
one more point. I'm sorry. One more point is that, my lord, the petitioner has claimed that there are various other legal heirs of the late husband, but only one of them has come, which is my learned friend's crime. And there are 7 or 8 other legal heirs who have not come, who have not approached this court. That is all, my lord. Then your lordship will decide, my lord, after.
So the specific case that they do not know what are the legal heirs of the deceased. Or kindly come to page 56 of my application. This is a proceeding taken out by the executor against the present petitioner.
Yes.
Page 66.
Yes.
But kindly take note of it. But kindly comes to paragraph 3 at page 68. Paragraph 3 at page 65.
Yes.
68, my lord.
Yes.
That the opposite party is the nephew of Abha Saha. He is trying to encroach the petitioner's property. So my position is of that of nephew of the deceased.
What is a good name?
My name is Shoibal Shaha. That is the opposite party. That will
Shoibal.
appear from page 66.
OP is the nephew.
OP is the nephew.
How the OPS come?
This is a proceeding under section 144(2) of the CRPC
Okay.
before the court bill.
Okay.
So the knowledge of the relationship is there. But thereafter, my lord.
So here is the OP is you, Shoibal sir.
Yes. Thereafter, my lord, kindly see the succession certificate. Page 50, my lord, by the district magistrate.
Page
5050, my lord. Yes, my lord. This is a certificate issued to the present petitioner by the district magistrate, where, my lord, at page 51, the name of the legal heirs, after a thorough proceeding, the district magistrate had come out. This is the actual procedure for obtaining a legal heir certificate. From page 51, my lord, kindly see the entry number 2, Shoibal Shaha, the name of the petitioner is appearing.
Yes. Yes.
My lord. My lord, the deceased once got sick and he was admitted to Shishu Mongol Hospital in South Kolkata. My lord.
Just a minute. Yes. Page?
My lord, page 26, my lord, the date is relevant. My lord, is 28th of June 2019. She got admitted in Shishu Mongol Hospital, page 26.
Yes.
My lord. 26, yes, my lord.
Avasha.
My lord, this is my lord Ramkrishna Mission Seva Pratishthan, Shishu Mongol. This is issued. This shows the name of the deceased.
Avasha.
Avasha. I'm deeply obliged. And towards right hand side, in the same column, same row, my lord, is the name of the guardian Shoibal Shaha. So I took the deceased for her treatment when the propounder, that is the executor, was, my lord, he was in London, according to my knowledge. But subsequently, she turns to be that no, after 2 days back, she came back to Kolkata. But he didn't turn up for her admission. Well, my name is there in the admission register. And my lord, kindly see the next page, page 27. Page 27. Towards
Yes,
bottom right hand side, Shoibal Shah's name is there and the relationship is the brother-in-law.
Yes, sign the consent form.
Yes, my lord.
Declaration
I'm deeply
form.
obliged. But thereafter, my lord, kindly come to page 29, the next page. But this particular document shows that I paid rupees, page 29.
Yes.
That I paid rupees 20,000 to Shishu Mongol Hospital from my ATM at the time of admission, because that was the shortfall, because hurriedly she was taken to the hospital and fund could not be gathered at that point of time.
Ramakrishna Mission.
Yes, my lord. The Ramakrishna Mission, that is slightly, my lord, blurred. That is 20,000 is appearing, my lord, in the stamp of SBI, my lord. And the date is left hand side, my lord, 28th of June 2019. This is the date when she was admitted.
Yes.
My lord, this money was tried to be, my lord, refunded when my auntie came to know that I paid, because she was otherwise, my lord, rich. I mean, she could manage her, my lord. So after she came to know that I paid the money, she said, no, why should you pay? I should pay you back. So thereafter, my lord, this is the check, the document at page 30. And this is very interesting. My lord, see the date, 8th of July 2019. My lord, she returned from hospital on 4th of July, discharged. My lord, thereafter, after coming to know on 8th of July, this check was issued. This is very vital. My lord, kindly see. Towards, my lord, the name of the payee is the Shoibal Shaha. Lord, kindly see the right hand side in whose name the check was, the drawer of the check. The drawer of the check is Abha Shaha stroke Mr. Surajit Kumar Shaha. Surajit Kumar Shaha. That is the propounder executor.
Yes.
And that particular check was not signed by Abha Shaha to the not to the knowledge of the propounder, but it was executed by Surajit Shaha himself. So it's not that I am an outsider, I am no one to the picture, I just dropped in. This check got dishonored. Next page 31. And thereafter, I was given the money by cash. My lord, thereafter, my lord, kindly comes to, there are several, my annexure E, it shows
No,
that
this was dishonored.
This got dishonored, and subsequent my averment is that this money was paid by cash. That is my statement. But thereafter, my lord, at the time of death, my lord, here the date is very important. My lord, kindly take note of 3 or 4 dates. First date is the 4th of January 2020. My lord, kindly take note of these 3 dates. That is the date of the alleged will.
Date of will.
Will. 14th of January 2020. My lord, thereafter, 13th of May 2021, the date of the deceased. Date of the deceased. 13th of May 2021.
Yes.
My lord, thereafter, 26th of June 2023. That is the date of grant of probate.
Yes.
My lord, thereafter, 13th of June 2024. That is when the application, this particular application was affirmed. And they did not take the point of limitation, and my lord knows the point to the limitation period is 3 years from the date of knowledge or the date of grant. So I am not going into that or citing any judgment to that extent. My lord, thereafter, the annexure E, page 33 onwards, these are the communications and the letters and emails at my instance for taking off, my lord, the lockdown passes, because that time the second phase of the COVID period, COVID-19, we are suffering. All of us are suffering. This is the first document 33. Here I address to the concerned police station, whereby I declared myself as that the deceased was the aunt. There is the first statement, the first line. My aunt, widow Shoibal Abha Shaha. And here the permission was taken for the persons 1, 2, 3, 4.
After death.
This is after death.
During the COVID
period, I'm demobilized. These are the 4 persons: Shoibal Shelbrifen, Shimoti, my wife, Surajit Shaha, the propounder executor, and Choitali Shaha, Surajit's husband, wife.
Surajit is the propounder.
He is the propounder and the executor. The next are the documents that was annexed. These are the extract from the email. That is why these are not that legible. But kindly come to page 35. This is the lockdown pass. This was the initial pass. It was taken. Subsequently, they changed the venue. That is why there are several passes taken for lockdown purpose. This lockdown pass was issued by the airport police station.
Yes.
But the names are very important. Shoibal, Shrimati Shaha, Surajit Shaha, Choitali Shaha. Propounder and his wife is also there. Page 36.
Choitali is his wife.
Yes, wife of the propounder. But the next page, lockdown pass. This was issued by the Bidhannagar police station, 17th of May.
Yes.
And the purpose is that towards bottom, Shraddh ceremony. Serial number 5.
Yes.
And the name of the passenger is at the top, the B, 1, 2, 3. Name of the owner, driver, that is Shoibal Shaha, and those 3 persons. My wife, the propounder and propounder's wife.
Yes.
And destination area is also given. Thereafter, another page 37, another lockdown pass. That is for the purpose of going to the Shamsan, Bali Shamsan towards bottom at the down.
Yes.
My lord, thereafter in vernacular, some extract of the WhatsApp communication with the propounder and the present petitioner regarding the modus, how the Shad ceremony and the other the rituals are to be done. Because the photographs are to be sent, their identity card are to be sent, otherwise lockdown pass could not be obtained. These are the support in vernacular. I have a better document than this. I am coming to that. But kindly come to page 41. Page 41, my lord, kindly come. But this is the email, by this particular email written by Shoibal SINP, my lord, @gmail.com to Surojit Shah @gmail.com. This is the propounder. The email was given.
Yes.
That is on 26th of May. This is for this purpose, kindly say one date is very important. The date of the Shad ceremony, that is also on 29th of May 2021.
Yes.
Kindly take note of it. So by this letter, this is to draw your attention that my aunt Widow Ava Saha had expired on 13th of May at her residence such and such. I have already done last rites at Shahnagar crematorium. Last rites means giving the fire, my lord. A brief Shad ceremony is scheduled to be held on 29th of May at Basanto Bose Road, that is Bhawanipur, where only 5 close relatives and 1 Brahmin will be present, maintaining all physical distancing owing to prevailing pandemic situation. Therefore, I would like to request you to issue lockdown pass in favor of myself and driven car such and such, once of office room, that was given so that he can approach the police authorities for the purpose of, and the body of what to be written, he asked me. That is why this body was given. They never denied this. But thereafter, some photographs showing that communication was given. And thereafter, page 48 is the photograph wherefrom I did the Shad ceremony. The Shad was done and performed by the petitioner before you. And he did not know me. He allowed an outsider to do the Shad ceremony. And my averment to that respect, my lord, kindly comes to, because I am trying to be very brief, because I know, because kindly comes to page 15, page 12, my lord. Page 12 towards bottom. Subparagraph U, last sentence. Page 12 of the petition. Subparagraph U, last sentence.
Yes.
However, your petitioner did the last rituals of the deceased, that is Pindodan. In their opposition, they did not dispute it. They never did, they did not deny it. So the knowledge of my heirship of Avasaha is not disputed. My close relationship and my address and availability was also not disputed. What is disputed is the mere technicality that I did not respond to the paper publication, but the special citation was not issued, and not the name list of the legal heirs have been given. They ought to have been given the name of the legal heirs in the petition. They did not do so. The plea they have taken, they did not know of any legal heir. But from these documents itself, it shows that they knew not only my position, that of a legal heir, but my attachment to the deceased, who took her to the hospital, paid money, they repaid the money, I did the last rituals, I did the Shad, Pindadan, and other thing. Thereafter, my lord, these are the basically against the may I come back at 2?
Yes, continue. How much time you will take?
My lord, if my lord is with me and the points they have raised in objection, if I could satisfy, I'll be relying upon a judgment of your lordship, whereby your lordship has held that mere general citation by publication is not enough when the legal year is not specially cited. My lord, this is, my lord, I could find it in the Monupatro by no other journal. It is, my lord, in re Ganesh Prasad Bose, deceased. PLA 233 of 2026, which was decided on 21st of June 2023. Kindly come to page 20, paragraph 20, my lord.
Yes.
But here they have, my lord, it is a similar, just the same case where, my lord, publication was done in this paper publication and the legal year was not given the special citation. My lord referred to paragraph 24 in that judgment. In the illustrations of section 263 of the Indian Succession Act, clause 2 reads as follows: the grant was made without citing parties who ought to have been cited. In the present case, the applicant being son of one of the brother of the deceased, and the applicant is having caveatable interest, but the respondent, by filing the application for grant of probate, had made a false statement, averment, and had not cited the applicant as party to the said application. In the present case, they did not cite it, hence the grant is revoked. Regarding, my lord, their point of revocation, my statement is that my aunt wanted to give the property to myself. My gesture was that if a lady, if any person, he gives up, he's the last thing, he will not get care. So I said, no, you do not do. I have no my lord, last for any property. If I get it, I'll do it to the charitable trust. That is my decision. But by way of practicing fraud, if someone says that I am no one, I do not know one, and I have no right to fraud. And regarding the allegation, regarding the will, my averment is at page 16, paragraph 25 and 26. Page 16, paragraph 25 and 26.
Page 16 of?
Page 16 of my application, my lord. That the suspicious circumstances, the word suspicious may not be written, but the resident in Siliguri, he went to his sister's husband's place. Thereafter, will is executed, though the registering office is at stone throwing distance. It was notarized. Thereafter, the signature of the bank is not telling. That is at paragraph 26. Signatures are not telling.
Yes.
25 and 26. So these are my humble submission, and before also that, let me contest the plane, no matter the will.
Probate grant drawn?
Yes, one drawn, but no steps taken. It is drawn, granted, drawn, but no steps have been taken because of the pendency of this application. We are not taking any step.
How much time you will take?
But half an hour.
Settle it.
That first hurdle has to be crossed. But I'll address it.
No, I am telling. Sense appearing for the executor. Sense appearing for the applicant. The applicant has filed the present application being GA1 of 2024, praying for revocation of the probate granted by this court. Counsel for the applicant has concluded his argument. Due to paucity of time, the learned counsel for the executor could not argue the matter. According case is adjourned. When? After vacation?
Any day, any day.
Let the matter appear on. Third, you will be available. Second, third?
Yes, second.
Second.
It could be on third, all of us will be available.
My lord. 3rd January 2024 under the same heading as parted at the top.
If you
Date
will
for
lordship's pleasure to fix a date, time, my lord.
That's why I put that because it will have it will come.
Yes, yes. I'm briefed.
Date for great.
Yes. Call.
I'm for the plaintiff.
Yes.
My lord, I'm for the respondent.
Now, my lord, this matter,
Hmm.
this is an undefended suit, and this pertains to insurance claim.
Hmm.
In this matter,
Hmm.
the plaintiff has multiple claims, but the principal claim is under two insurance policies, which were repudiated by the insurance company defendant. And the other claims are a direct result of repudiation of the insurance claims. So, my lord, first I'll place my facts of the case, and my lord, I'll I'll try to satisfy your lordship
Hmm.
regarding validity of my claim,
Hmm.
insurance claim,
Hmm.
and thereafter the other claims will follow.
You are for the?
I am for the plaintiff, my lord.
Who is for the defendant?
My lord, my
I'm
learned
for the
friend.
Have you
defendant.
adduced the evidence?
Your lordship,
You
no,
have
no.
not adduced the evidence.
No, because it was undefended suit, your lordship, because of that reason.
Okay.
My learned friend has cross-examined
But yes,
both
Not
witnesses.
adduced the evidence.
Not adduced evidence.
Okay.
Now, my lord, before I go to the facts of the case,
Hmm.
I will indicate what are the claims in this suit. That is in, my lord, paragraph number 58 at page 24 of the plaint.
58.
Paragraph 58. I have given it in a tabular form.
Yes.
In page 24 of the plaint.
Yes.
Now, my lord, two insurance policies are involved here.
Hmm.
One is a machinery breakdown policy for cold storage,
Hmm.
and the other is stock insurance policy in cold storage.
Correct.
So one claim is 6,103 for the machinery breakdown. It's a paltry amount, but this is very important. I'll come to that, my lord. And the stock policy claim is 7,92,000 to 2,900. 7 crore 92 lakhs 29,155, and the interest calculation of interest up to the date of filing the plaint, and this interest is calculated on the basis of the interest I am paying to the bank from which I have obtained the financial assistance for running my business.
Yes.
Fourth claim is, my lord, the compensation due to loss of business opportunities,
Yes.
which I pleaded. Fifth one is the expenses incurred for disposal of contaminated stock, which is my statutory responsibility under the act which governs my business.
Yes.
And claim number 6 is expenses incurred in repairing chamber number 3 of the cold storage. Now, my lord, this claim I have filed an application for not pressing with a liberty under order to rule 2. And while presenting the plaint, I also obtained a leave under order to rule 2. Because here the expense.
So you are not claiming this?
My lord, I am at present I am not claiming this, because out of this 98 lakhs, it was based on quotation for the engineering firm which were engaged for repairing. I could spend around 15-20 lakhs, but due to dearth of money, I could not proceed with the repairing work. So I'll incur these expenses in course of time, but at present I have not incurred these expenses. And my lord, the cost of additional interest.
Claim 6, you are not pressing.
I am not pressing, and that application is pending. Your lordship's direction was this will be disposed of along with the suit.
For not pressing that.
Not pressing them with liberty to for leave to proceed further. And my lord, 7 is the interest that has to be computed.
Hmm.
It is post institution of the suit.
7 is the
additional interest which have accrued. Suit. Yes, my lord. Now, my lord, the fact of the case is that the plaintiff runs a cold storage for potatoes. It is in Bardhaman district. And potato cold storage business is regulated by a statute, West Bengal Cold Storage Act, and rules framed under the act. So, as per this act, the cold storage owner, the revenue of the cold storage owner is the rent per quintal, which is payable by the farmers for storing the potato in their cold storage, and the rate is determined by state government,
the parties don't have any role to play there.
Notified road, notified rates.
Yes, my lord.
Or time to time it is.
No,
changed.
it changes every season, but the determining authority is the state government. And as per the rules framed under the Cold Storage Act, the stock, potato stock, has to be insured by the cold storage owner, but the choice of insurance company is determined by the state government. The plaintiff doesn't have any choice of picking up a particular insurance company for insuring the stock. It is a state government nominated insurance companies through which the stock can be insured. I'll show the rules, my lord.
Okay.
And the insured value per quintal potato, that rate is also determined by state government. There also the parties, the cold storage owners or the farmers don't have any role to play. I'll show the rules, my lord. These are relevant for my claims. Cold Storage Act. Well, I'm handing up the Cold Storage Act, the relevant rules.
By reading the cold storage, it can whether court cannot go to the cold storage. No?
It's already cold actually right now. My lord, may I? My lord, I'm handing up the book. My lord, I have a copy. If your lordship so pleases, I'll give a copy.
No problem.
Insurance of agriculture produce in cold storages. For the purpose of section 15, agricultural produce stored in a cold storage may be insured against loss or damage by fire or due to breakdown of the refrigeration plant or machinery through failure of electricity or against the risk of riot or civil commotion, if so desired by the hirers in writing. So hirers means the farmers who put their stock in my cold storage. Now, government assumes the role of representative of the hirers for nominating insurance companies and fixing the rate of insurance premium and the insured value. Hirers in writing with a company or companies approved by the licensing officer for an amount not less than the market value of the produce.
Where from you are reading?
My lord, I'm reading rule 14.
14. Okay.
Yes, my lord.
Okay.
For the purpose of section 15, agricultural produce stored in cold storage may be insured against loss or damage by fire or due to breakdown of the refrigeration plant or machinery through failure of electricity or against the risk of riot or civil commotion, if so desired by the hirer in writing with a company or companies approved by the licensing officer for an amount not less than the market value of the produce on the date on which it was deposited in the cold storage. So, my lord, here the choice of insurance company is totally in the hands of the licensing officer, who is a government, which is government, Department of Agriculture Marketing. Now, my lord, notification where
As per the Insurance Act, it is applicable. The other authority can determine the insurance premium of the insurance.
My lord, this act says so. This act says so, and one writ petition is pending on this, whether insurance company can, but it is not on the choice of insurance company. It is on the question that whether after fixing a rate as market value by the state government, while it comes to paying compensation, a different rate can be fixed by government. So that.
But how the insurance claim is to be ascertained? Insurance claim is to be ascertained as per the quantum of the product.
My lord.
And the value of the product.
My lord.
Correct. And suppose the farmer or the contractor taken the 100 quintal of potatoes to the cold storage. So what would be the market value of that potato on that day? While he is kept the materials potato in the cold storage.
That is a relevant date.
Correct. That is a relevant date. Suppose, unfortunate, any things has happened, fire or any
My lord.
incident has
Yes, my
happened,
lord.
or theft, whatever it is, which is covered under the insurance. So, how the insurance is taking the premium from the contractor? Because insurance premium is to be taken, and the premium is to be decided as per the value of the product.
My lord.
As per the value of the product.
Your Lordship, if I may, the government is deciding the value for per quintal for a year. Basis that the quantum is arrived at, and on
Correct.
that quantum the premium is arrived by the insurance
That's
company.
right. So, with regard to the quantum or the rate of the product which has been stored in the cold storage, that rate has been given, has been provided by the state government.
Lordship.
And on the basis of this, you are deciding the premium.
Your Lordship.
My lord.
That's I'm telling.
My lord. And my lord, in my understanding, this provision is ultra vires, but that has not been challenged anywhere
That's right.
as of now.
After first line I'm going to, then I am asking this. So how this provision has been accepted by the insurance company? But not is the question
Not,
here.
it is not
It is
material
the
here.
question
Now, my lord.
Yes.
It exhibit number publish. Now, my lord, I have disclosed the document, the circular, and the minutes of the proceedings held by the government of West Bengal marketing department, agricultural marketing department, for determining the rate of insurance. Rate of insurance, value of sum insured per quintal of bag, and nomination of insurance companies. Now, that document is Exhibit B. That document is Exhibit B at page 51, my lord.
Volume 1, page 1 of the judge's brief.
Volume 1, page 1A of the judge's brief, my lord. My judge's brief. Pagination needed. It is page 1A, my lord.
Yes.
And now, my lord, in this suit, none of the documents, veracity of none of the documents have been challenged. Now, my lord, this is the notice. It was circulated to all the cold storage owners dealing with potato. Now,
What is the definition of licensing officer?
My lord, licensing officer is officer designated under the Cold Storage Act, West Bengal Cold Storage Act. It is the assistant director designation is assistant director.
Assistant Director of Civil Supply?
No, assistant director of agricultural marketing.
Agriculture and
Marketing.
Yes.
Now, my lord, this is the document circulated for fixing rate of insurance premium per quintal, sum insured per quintal of potato loaded in the cold storage, and also nomination of insurance companies, which your lordship will find in page 1E, attachment sheet of the minutes, my lord.
1E.
1E, my lord. That is also part of Exhibit B, my lord.
Attendance sheet.
Attendance sheet, my lord. They were called upon to attend. 8 is United India Insurance Company. United India Insurance Company.
Yes.
9 is also United India Insurance Company. 2 officers came.
So now what is the dispute here?
Well, the main dispute is regarding interpretation of the covering clause in policy, in the stock policy, and the other is whether the claim is validly repudiated or not under the machinery breakdown policies.
So
Now,
on the date of incident.
On the date of incident.
On the date of incident, what was the quantity of the?
No, that is not in dispute, my lord. incident is contamination, loss of huge amount of potatoes, around 1 lakh quintal of potatoes due to contamination by leakage of ammonia in the refrigeration chamber. And the claim has been repudiated on the ground that contamination is not covered as an insured peril unless there is a rise in temperature, which the plaintiff is disputing. So far the stock policy is concerned, it is entirely a matter of interpretation of the contract. And so far,
So what is how you approve how these potatoes have been damaged?
Well, it is by contamination, and that is a fact admitted by the admitted.
Contamination is admitted.
They have not filed written statement by disputing that, as well as the surveyor appointed by the insurance company. He has also admitted that there has been contamination, which caused the total loss of entire stock in chamber number 3. And in the repudiation letter also, the insurance company indicated there is contamination, but since there is no rise of temperature for a certain period, that's why the claim is not payable. So far the stock policy is concerned, the stand of the plaintiff is that to cover a loss caused by contamination, rise of temperature is not a necessary ingredient. So that is a matter of interpretation of the insurance contract.
But the surveyor says how it has been contaminated?
It is by leakage of ammonia, my lord.
Leakage of ammonia.
Ammonia.
Ammonia is leakage.
But the ammonia is used, liquefied ammonia is used for refrigerating the stock.
Correct.
Now, due to sudden rise in pressure of ammonia vapor, one valve broke in the chamber number 3. So ammonia spread in the whole chamber. Now within an hour, that damage was repaired. So further leakage and further rise in temperature was arrested. But in the meantime, the ammonia got spread in the whole chamber, damaging the entire potato stock, damaging in a sense, the potato stock became unfit for human consumption, which was sent to a laboratory of Vishwabharati University professor, and he gave an expert opinion that these potatoes are toxic and has become toxic due to contamination, not fit for human consumption. It was a total loss so far the chamber is concerned. And the report of Vishwabharati University also has not been challenged, rather that was relied on by the surveyor. So the factum of contamination due to breakdown in the machinery and leakage of ammonia is an admitted fact. That has not been disputed in the pre-litigation stage also.
So where is the denial? By which letter they are denied for payment?
My lord, that is page 194, volume 2 of the judge's brief. Volume 2 194, I'm sorry. Judge's brief. My lord, this repudiation first came by an email, and on the same date of email, a letter was posted which we received on the next date, my lord. So I'm reading out the email itself. No, you are giving me a wrong page. Letter of repudiation. My lord, I'm extremely sorry, my lord. It should be page 197. That is exhibit CC, I believe. It is exhibit CC. Hey, amake plain dichchis re judge's brief noy. Judge's brief. That is exhibit CC, my lord.
Yes.
I'm reading out from the email, my lord. The contents are both the same.
Yes.
That is on 29th of December 2022. Repudiation of claim under policy number so and so ending with 46. That is MBD policy. MBD stands for machinery breakdown policy. And policy number so and so is DOS policy, which is deterioration of stock policy.
Yes.
Sir, madam, kindly refer to the claim lodged by you under policy number so and so, that is machinery breakdown policy, and policy number so and so, that is DOS policy. Via intimation letter dated 22 May 2022. We had deputed the surveyor for assessment of the above loss. On close scrutiny of the papers submitted by you and the report submitted by the surveyor in support of your claim vis-a-vis the terms and conditions of the policy issued, we regret to inform you that above both claim have been repudiated under the following exclusions and clauses. Now, my lord, for the time being, I'm omitting machinery breakdown policy. I'm indicating stock policy, my lord. DOS exclusion in the next page. Exclusion number 2.
DOS is damage.
DOS, my lord, deterioration of stock. It is stock policy, my lord. Any damage to the stock due to rise in fall of temperature caused by stoppage of any section or sections of the refrigeration plant for less than 24 hours following an accident in the refrigeration plant and machinery specified in schedule and covered by concurrent machinery insurance policy. So the ground was that there was no rise of temperature for 24 hours.
Any damage to the stocks due to rise or fall both in temperature caused by stoppage of any
refrigeration plant.
Section or sections of the refrigeration plant for less than 24 hours following the accident to the refrigeration plant machinery specified. Yes, then.
Now, my lord, second exclusion is any damage to stocks caused by rise or fall in temperature due to stoppage of any section of the refrigeration of plant for repairs. My lord, this exclusion is not required because there was a breakdown, admittedly. So, the first exclusion is relevant here, that there was no stoppage of, there was no rise in temperature for a certain period, that is 24 hours. So, the claim is not payable.
Yes. So when you put the stock in the cold storage,
it was loaded on 19th, my lord.
And when the incident
no,
was
I'm sorry, my lord. I'm sorry. It is not on 19th. This loading process, the loading process starts from 1st March. That is the post-harvest season. And I started loading from 1st March, and loading gets completed within 3-4 days. The chamber gets filled. The insurance was effected from 19th of March, no, 19th of May 2022. And the loss happened on 22nd May 2022.
19 and 22.
22nd.
19 you are completed.
No, 19 the insurance policy started.
That's why insurance policy started.
Started, my lord. The coverage started.
Correct. And incident was occurred on
22nd, within 4 days.
4 days.
Your Lordship, with your kind permission, may I correct the date? Actually, that's not factually correct. The accident occurred on 19th. Insurance was effected on 18th.
18th. I'm sorry, my lord. I'm extremely sorry.
Within 24 hours.
That's why that's I'm telling.
Within 24
that
hours.
To the 24 hours, how it can be?
My lord, I'm coming to that, my lord. This policy is a continuous policy. The insured, the plaintiff and the defendant, they are having a contractual relationship as insured and insured for last 20 years, more than that. And there has not been a single claim against them. That I have pleaded, and that is not a disputed fact. Now, what happens, my lord, in case of insurance of cold storages, after expiry of one term, the renewal, once the insurance term is for 1 year, it ends, subsequent terms come. So it's a continuous insurance process. It's not the first time
renewal.
It's a renewal policy for more than 20 years, my lord. Before that, I have disclosed records from 2014.
No, that's correct. That's correct. With regard to on 19th, 18th, 18th May, you have taken the policy.
My lord, my proposal is on 6th of May.
6th of May, your
Insurance company issued the policy from 18th, because previous policy was in force.
When you have deposited the renewal amount,
a premium I have paid, my lord, before, because under section 64 BV, unless premium is paid, insurance policy cannot be issued.
That's why the insurance policy starts when they received the amount.
My lord.
When they received the amount. So when we have issued, when you have deposited the amount.
My lord, I have deposited the amount. I will. It is not a subject matter of dispute that whether premium was paid or not.
So
but I'll inform your lordship. That is not their case also, my lord.
Okay.
But I'll satisfy your lordship.
So only these 24 hours. Only these 24 hours.
Within 24 hours, this subsistence of this
case is only 24 hours.
24 hours.
So you have there as per submission, one line submission is made, but that is the crucial point. 18th, what is the time?
It is around 6 o'clock in the evening.
In the insurance, what is the time of starting your
12 night?
12:34, your lordship, and not even 24 hours. Within few next day evening, it has happened.
It doesn't matter, my lord. Because insurance company has not questioned the subsistence of insurance cover
earlier.
Not under this subject policy also. It was not a stand of the insurance company. The policy is not covered. The claim is not covered. They are saying it falls under exclusion.
So that's what I'm telling. See, exclusion, how the exclusion will taken into consideration. Exclusion is to taken into consideration as per their case. I don't know. I am not as per their case and as per this clause. The insurance what you have taken, the time of issuance of the insurance certificate, insurance policy, time of issuance of the insurance policy within 24 hours. That
No. That is not the case. My lord, the clause is, kindly see, clause is if the refrigeration system fails and it remains failed, restarted for less than 24 hours. If the temperature rises for 24 hours due to failure of refrigeration.
Stoppage of any section or sections of the refrigerator plant for less than 24 hours following the accident to the refrigeration plant. So when this stoppage was started?
6 in the evening.
There is a report.
Yes, my lord. There's a report, survey report.
That's in the evening of 19th.
On 19th. And it was repaired within 7.
Within?
7 o'clock. 7 in the evening.
1 hour.
1 hour.
Okay.
Now, my lord, it is not their case that within 24 hours of policy.
Now I understand. Yes.
Now, my lord, may I come to the facts of the case, my lord? Now, my lord, my lord, policy is at page 47. I'm not showing it. It is the schedule of the policy and time of issuance of the policy. And it is not the case of the insurance company. It is not a case of the insurance company that after issuing policy within 1 day, loss has happened. Even if the loss had happened within 1 hour, it would have been covered. Now, here, my lord, the state government had nominated 4 insurance companies, out of which, with the defendant, I had 20 years of relationship of insuring my plant. I have disclosed all the previous policies. Not all, but at least 10 decades. From 14-15, I have disclosed the policies. So, we have a long-standing contractual relationship without a single claim. After I submitted a proposal form for insuring my plant, the insurance company sent its own surveyor.
Correct.
Surveyor to check whether my plant and machinery are in sound condition or not.
Correct.
The surveyor was nominated by insurance company. So that survey report, we had been given a photocopy. We sent a letter to produce to the defendant. It was not produced, so it has gone into evidence as secondary evidence, and veracity of that letter, the report has not been challenged. That report is in page. The report is in page 54. The judge's book. report is in page 50. It starts from page 53.
Yes.
No, this is not that report. This I'm showing the Sujan Chatra report. My lord, I'm sorry. The report is from page 60.
Exhibit F.
Exhibit F, my lord.
Yes. This is a report of surveyor.
It is report of surveyor before issuance of the policy. It's called pre-risk acceptance policy.
Yes.
Under instruction from the Oriental Insurance Company Limited, Kolkata Divisional Office number 4, undersigned did proceed to village Bishnupur, PO Rasulpur, PS Memory, District Purba Bardhaman, for the purpose of pre-acceptance survey of the plant and machinery of Tirupati cold storage. Whilst installed in their machine room of the above cold storage situated at above mentioned address.
Yes.
The date of survey is 8 May. So after I given a proposal, insurance company sent its surveyor to check whether it's safe to insure my plant and machinery. And he gives a detailed report of all the equipments and parts. Now, after this report was given to the insurance company, insurance company, without any further query, issued the insurance policy for deterioration of stock, DOS, and machinery breakdown policy, that is MBD policy. And the claim arises from those two policies, my lord. Now, my lord, so far these two policies are concerned, these are standard form policies, which means here only the location of the insured premises, the quantity of the goods insured, and these are only customer specific. But terms and conditions are decided by the insurance company. Here the insured has no role to play for deciding. It's a take it or leave it sort of policy. So these are standard policies. While this policy came into operation and the entire cold storage was loaded, this accident happened. How the accident happened, that has been described in detail by the surveyor. In their survey report, two survey reports he published. One is under the DOS, one under the MBD. Even given photographs of the broken parts of the valve, saying that the claim under the machinery breakdown policy is payable because it is an accidental breakdown. Whereas for the DOS policy, the surveyor said that there is contamination, but since there is no rise in temperature, the claim is not payable. Now, before all this happened, lot of developments took place. Not with regard to my insurance claim vis-a-vis the defendant. There was farmers' agitation for rate of compensation. Insurance state government determined the compensation which I am liable to pay. To the farmers, because these policies, my lord, this stock policy is basically in the nature of liability insurance. I am holding the stock on behalf of the farmers, though I am paying the insurance premium. If there's a loss, whether insurance company pays me or not, I am bound to pay to the farmers whose stocks are destroyed. Now, state government decided a rate of compensation, which my client challenged before the Honorable Calcutta High Court, which matter is pending. Exaggerated rate was fixed for compensation. I have challenged the rate there. And in an interim order passed in that writ petition, I was called upon to deposit rupees 3 crores as interim payment. So I paid these 3 crores as interim payment by borrowing money from other sources.
For why?
For
what?
For part compensation.
Of this?
for the farmers. For the farmers. Now, 3 crores as an interim payment as per direction of the court I had paid. Now, there was further agitation. There was further agitation for total payment. Now, insured didn't, the plaintiff doesn't have money because the profit margin, I have disclosed the balance sheet also, profit margin in this business is very moderate. So that much of 7 crores of rupees, they don't have. So there was a agitation in front of the gate of the premises. Even the staff and the management members were beaten up inside the cold storage premises. FIR was lodged with the police, CCTV footage was given. So these facts I have stated in my pleadings, and these are not disputed, these facts. So when this process went on, there was further negotiation with the farmers organization. As per this negotiation, I paid another 1.5 crores by further borrowing money from market with a very hefty interest rate on that. So part compensation has been paid. Now, after payment of almost 50% of 60% of compensation, the farmers allowed us in the month of end of May to operate my cold storage. Because of the blockade and violence and law and order situation in the cold storage, the plaintiff could not take out the contaminated stock which was there in the chamber number 3. As a result, the contaminated stock started rotting, and I had to incur expenses because since the stock is there, I had to run the refrigeration process of the cold storage, consuming huge power and also maintaining the overhead costs. So this way my cost got aggravated because of the insurance claim was not paid. And ultimately in the month of December, 29 December, my claim was repudiated by the insurance company, which are under challenge in this suit.
So what is the writ petition?
My writ petition is regarding rate of compensation. State government said rate of compensation will be 2200. I said, no, you determined it is 1370. So it should be 1370. So it is a dispute not pertaining to the insurance claim. It is a dispute pertaining to the rate of interest, rate of compensation I am liable to pay to the farmers. So that matter is still pending. Now, my lord, one aspect in this claim, in this dispute, is very significant. Rather, two aspects are very significant.
Yes.
One is, my lord, the insurance policies, both DOS and MBD, are standard policies. It is totally drafted by the insurance company. Second is, it is a condition for indemnity under stock policy that my claim under DOS policy, machinery policy, should also be payable. So the scheme of the whole insurance is my both claims should be payable. Now, when this survey process was ongoing and my claim was pending before the insurance company, the surveyor gave a report stating that claim for machinery breakdown policy is payable 6,000 rupees and claim for DOS policy is not payable because there is no rise of temperature in spite of contamination. So I wrote letters challenging that finding of the surveyor so far the stock policy is concerned. And my stand was that as per the scheme of the policy, DOS policy, contamination is a separate type of peril under which rise in temperature is not a precondition for obtaining indemnity. That was my stand, and I gave a detailed explanation of the clause. While this correspondence was going on between the defendant and the plaintiff, on 6th of October, the discharge voucher, the concerned officer of the insurance company, the divisional manager of the division from which I obtained the policy, had sent me a discharge voucher. Saying that your claim is payable to the extent of, under the machine policy, 6,103. You execute the discharge voucher. It's a template discharge voucher issued by the insurance company. You fill up the discharge voucher and you submit the other documents like no objection from bank endorsement, because my machines are hypothecated to bank. So you give these documents and we'll pay the claim. So when I received the discharge voucher, next day the puja vacation started. So I could not submit the discharge voucher after execution because I had to get it endorsed from bank and the insurance company was also closed. So on 10th of October, I got the endorsement from bank and I also attached the accompanying document, and the executed discharge voucher was sent by email to the insurance company. Now, giving me the factum of giving me the discharge voucher and then my forwarding the discharge voucher are not disputed by the insurance company. These facts are not disputed. Now, my lord, why I emphasize on submission of this discharge voucher is for two counts. One, to show that my claim under the insurance MBD policy was payable, and it is admittedly payable by the insurance company, which they later resigned it from as an afterthought.
No, not with regard, that is a DOS,
No,
not machinery.
Well, machinery.
Machinery 6,000 rupees.
Yes, that also repudiated. Both repudiated.
Okay.
Despite issuance of discharge voucher and receipt of executed discharge voucher by 10th of October, it was repudiated in 29 December. So why I place emphasis on this discharge voucher? Because it has a statutory significance, significance under law. The discharge voucher was given to me and I executed it and submitted. That is an undisputed fact. This discharge voucher is a clear admission of liability by the insurance company. Discharge voucher. My lord, kindly come to page 159. I would like to show the discharge voucher, my lord. It is in volume 2. My lord, this is the email.
Yes.
And the covering letter by which, as attachment, I have given the discharge voucher. Your lordship can find the attachment.
Yes.
At the bottom of the page.
Yes.
And next page is the covering letter, my lord, and the page 161 is the discharge voucher. Kindly see, my lord, this discharge voucher is in the template of insurance company. And my lord, 6044 is printed.
Yes. 6,044.
44. It's a printed.
Yes.
So it was sent to us, and we executed it by by a director of the company, Shiv Prakash Bhattar, whose signature is beside the revenue stamp,
yes.
And at the bottom the endorsement of Punjab National Bank.
Yes.
So this is a discharge voucher and the certificate of incorporation, other necessary documents I had attached.
Yes.
Now, my lord, I would like to show the law governing the process of settlement of insurance claim. My lord, this is given by, this process is laid down by Insurance Regulatory and Development Authority of India, which is a statutory body created as a creature of statute, and it has power under section 26, if I correctly remember, under the act to frame regulations for governing the business of insurance, government insurance companies as well as private insurance companies. Now, may I hand up a copy of this? তোমাকে দিয়ে দিচ্ছি আমার কপিটা দেখি আমার কপি ওর কপি My lord, kindly come to internal page 24. That is a relevant, these are regulations. Page 23, my lord. That is regulation 15. 15, my lord.
Yes.
15 is claim procedure in respect of general insurance policy. We are a general insurance policy here. Now, my lord, 1 to 5 is not relevant here. Kindly come to, my lord, 6. Next page.
If an insurer
If an insurer on receipt of survey report finds that it is incomplete in any respect, he shall require the surveyor, under intimation to the insured stroke claimant, to furnish an additional report on certain specific issues as may be required by the insurer. Such request may be made by the insurer within 15 days of the receipt of the final survey report, and provided that facility of calling for an additional report by insurer shall not be resorted to more than once in case of claim. So they had to seek, if they were not satisfied with the survey report, so far MBD policy is concerned, they had to seek a clarification. Now, and to intimation to me, no clarification was sought by the clear finding of the surveyor that the insurance claim is payable because the damage was accidental. Now, my lord, kindly comes to clause 8. For this regulation, I am placing so much of emphasis on the discharge voucher. On receipt of the final survey report or the additional survey report, as the case may be, and on receipt of all required information and documents that are relevant and necessary for the claim, the insurer shall, within a period of 30 days, offer settlement of the claim. So, insurance company offers settlement of the claim by way of issuing a discharge voucher in template. So, my lord, this discharge voucher, giving me a discharge voucher of 6,000 rupees, 6,044 rupees, is in admission of liability to that extent under a statutory duty of the insurance company.
So you mean to say the page 161, that is a discharge certificate, that is in compliance of the clause 8.
Clause 8.
That is your
that is my stand, my lord. Now, my lord, thereafter, insurance company, because of this repudiation, after this claim was repudiated, I had sent a letter to the insurance company giving a detailed commentary and explanation why the claim
repudiation is wrong.
Repudiation of claim under both policies is wrong. Initially, I gave a letter because I didn't know that my machine policy will also be repudiated, claim will also be repudiated. I gave letters on stock policy explaining that why contamination in itself attracts indemnity under insurance coverage. Why rise of temperature is not necessary. And that is a question of pure interpretation of the contract. I will now, my lord, my junior says time is up to 3.
Yes, continue. 3 minutes is there. You can complete.
My lord.
3 minutes to 3.
You complete within 3 minutes.
My lord, I will not be able to complete in 3 minutes, my lord.
Okay. No.
My lord, before I go to the insurance contract, I will indicate one judgment of the Honorable Supreme Court, which says that if an insurance company wishes to repudiate a claim, Galada, if an insurance company wishes to repudiate a claim, it has to clearly specify under which clauses the claim has been repudiated. What are the grounds of repudiation? In my case, insurance company has stated the grounds of repudiation. I am not on that. What I am on is, insurance company is not at liberty to go beyond the grounds of repudiation as stated in the repudiation letter. So, my lord, that judgment I am not reading out. It is
Why beyond the grounds of reputation you say?
my lord.
Why you are telling that they have gone beyond the
No, they have not filed any statement of defense.
correct?
My lord, what I am submitting is I don't know what submissions come from my from the bar. So I'm just showing your lordship the position of law that they cannot go beyond the letter of reputation.
Always,
My lord.
always not in the insurance. If suppose today any so cause was issued to you, and you given the reply to the so cause, and challenging, but your so cause was not accepted, and you challenge that. Subsequently, you cannot say no. This is further ground.
Further grounds. Exactly, my lord. That is a common law principle, my lord. I'm not
Common law.
going into the judgment. I kept it
Because they cannot go beyond the reputation.
beyond the repudiation, my lord. Now, my lord, I'm coming to.
Okay, now next, come to next day.
If your lordship kindly fix it on a particular date.
Particular date, then it will be a February. I don't think February also you will get. So suffering for the plaintiff, so suffering for the defendant. Counsel for the plaintiff has argued at length, but due to paucity of time, argument could not be completed. Fix, give the date. What time? 27 January. 27 January at 2 p.m.
My lord, one innocuous prayer, if I may permit to make. My lord, because of this failure to repay our loans, all arising out of this insurance claim repudiation, a sale notice has been issued against my client's property. It's a NPA. It had gone NPA 6-7 months back, 5 months back. Now a sale notice has been issued.
Who?
So by the Punjab National Bank, my lord.
Under sale notice.
Sale notice.
NPA declared.
NPA declared sale notice.
You are MSME. You are MSME.
No, I'm not an MSME.
So what can be done?
My lord, I'm only praying for a prior date, fixing a prior date.
Prior date, that's I can give, but time I cannot. Prior date I can give, the first, second, third, whatever it may be. But the problem is the time.
Then, my lord, let it be fixed at 2 p.m., my lord. I'm deeply obliged, my lord. And my lord, one more prayer, my lord, let it be part heard, my lord. My lord, I have almost gone more than 50% of the matter.
That's part. Purpose good.
Grateful, Your Honor.
I am for the petitioner,
My lord, I am for the respondent.
Which one?
Seventh.
Fixed matter, no?
Yes, my lord. My lord.
3 p.m. fixed.
Fixed matter.
2-3 p.m.
My lord, this matter number, item number 6 is adjourned, my lord.
7.
It was.
Yes.
My lord, there were 2 dates fixed, my lord, on 13th and 16th.
Ah.
For hearing my learned friend, my lord, we have made our submission. My lord, last week, my lord, they had mentioned this matter that they had some difficulty for the matter to be taken up today.
Yes, my lord. My lord, Mr. Ghosh would be arguing on behalf of the respondents. My lord, he had some difficulty. That's why I had mentioned it earlier this week. My lord had been pleased to adjourn the matter.
Which item number 7?
Item number 7. It was fixed on today as well as on 16th. My lord, we had sought an accommodation only for today.
So suffering for the. It is fixed tomorrow.
16th. My lord, 16th.
I don't understand. तीन लोग ये तो आज है तो मंडे जाने तो फरवरी में February. So suffering for the petitioner, so suffering for the respondent. You are for the respondent?
Yes, ma'am.
The matter is especially fixed today at 3 p.m. as well as on 16 at 3 p.m. 3 p.m. But in 16th of December 2024 at 3 p.m. But as per the submission made by the counsel for the learned counsel for the respondent submit that it is not possible for the learned arguing counsel to appear before this court. Accordingly, case is adjourned. Let the matter appear on 7th February at 2 p.m. Yes.
My lord, the 16th date, my lord, 16th.
16 already, they have mentioned earlier.
No, my lord. We had mentioned only for 13th, my lord.
I already fixed that. It cannot be go part by part.
My
sir.
lord, my lord.
My lord, then 16th is also adjourned.
Great.
Yes.
But I was on legs. But to keep it very short, we had given notes of arguments earlier.
Your
Now,
copy
take
has
into
not
account. No, I had given it much earlier. You have got it 1 year ago.
That was
1 year ago. Now,
Before starting argue.
No,
I've still not.
I have not yet got his notes. That's the reason I said.
No, you had got it 1 year ago. You had got it 1 year ago.
I don't have it 1 year.
It was served on everyone, including the
Because
court.
I remember Mr. Bachowatz is appearing for the secretary.
But I have barely 25 minutes. I will give him
These are
one
for-
more. I'll give him one more copy of something else now.
No.
Please. Now, Millard, what we've done to keep it short is, not in that same note, I've added a few paragraphs here and there. But so your lordship can replace that, and I'll hand over a copy of these replaced notes to my learned friend also.
Right.
Now, Millard, your lordship will not be troubled with too much of the note, perhaps. I'll keep it very short because not everything is there in the notes. Now, the first point my learned friend Lord argued, Lord, apart from Lord, of course, intimidating me with his height, Lord towering over me.
No, I was actually thinking aloud, Millard, he is a secretary who is no more in the school. I don't know whether he has a locus to even argue all this. It's the contention of the plain.
But I've been made a party.
Counterclaim is a secretary who is.
He wants one more round of argument. Lord, he's had his argument.
As intervener, as defender number 8.
No, I'm not an intervener. I'm
He was
defending.
a secretary who is no more there.
I'm a defender.
Yes, he's a secretary is no
But
more
he's
there.
had his same, Lord. He's had a reply to reply to
Taken
reply.
his benefits and is gone. Now,
But does he want to make submissions once more? Then I'll sit down.
Is it factually incorrect that he's taken his benefits and he's left the school?
Where do you find this? Is it anywhere in your pleadings, Mr. Doctor? My learned friend has had his reply to reply. It's high time he sits down.
Okay.
But he must know where he's overstretching his blood. Now, Milord, number one. Lord, the first point. Lord, who am I? Now, for this only, your lordship will take my notes. Lord, number one, I am an ex-student of Para A1. I am an ex-student of the school. Number two, I am a direct beneficiary under the will, and your lordship will not find too many under the country. The will provides that a certain number of students will be paid for in their entire education and other needs taken care for under the will of the founder. But those people are called foundationers. He is one of those foundationers of the school. So, he is grateful to the school because it's taken care of his entire. Number three, he's been the principal of several eminent schools. Dr. Graham's Home, which is a very well-known school in Kalimpong, National Gems, etc. Then, number three, he was rector in two of the Well and Goldsmith schools, and he left it because he got this offer. He left it midway to join as the secretary. Now, guess who had appointed him? These two very gentlemen. These two gentlemen had appointed him, and what did they do? They held a meeting without notice to the other four additional governors. There were 6 governors admittedly at the time when the suit was filed. Without giving notice to the 4 other governors, they held a meeting and removed me. So, the suit was to start off with. The other 4 then filed the suit, saying this has they not reappointed me. They reappointed me.
When?
Before the suit was filed. They reappointed me. Who? The other 4 governors. There were 6 governors. 2 held a meeting without the other 4. The other 4 said, look, the meeting is without notice to me. We revoke the removal. Then the 2 of them held a meeting and removed those 4. So those 4 have filed the suit, making me the defendant number 8. This is what the suit was about and for framing of a scheme. So this is the situation. So, ex-student, well-known, eminent. Then, acting as the secretary of the school, removed. Then, please turn the page. So para 5 is about that chapter of removal. But para 6, he was a member of the Legislative Assembly as the nominee of the Anglo-Indian community. That's para 6. He is also on the Minorities Commission. My learned friends make so much of minority, he is also there on that. So, this is his credentials and background. And my learned friend says, why should I have a say? Now, dealing with his submissions. His first submission, as I understood it, was that, look, the court cannot touch the scheme. The scheme has been framed, it cannot be touched. Why? Because some orders passed by court. This is one submission. The second is, the school is a minority institution. Any change that you make today may tinker with its existence as a minority institution. For that, he relied on a certificate of 2010. These are the 2 points that I take care of first. Now, as far as this power to alter, the history is this. Your Lordship will take the plaint. Please take the plaint. I'll just take 3 seconds, on it. But volume 1 of the plaint, page 31. But please comes to page 74. I'll not keep it as short as possible. This is right from the will. But this is his will. And at page 74, your Lordship will find. No, this is not the will. I want the will. Hold on, will. Lord, I'm sorry, wrong page number. Lord, if your Lordship will turn to page 56. Page 56. That's the last page of his will. Typed copy is at 56A. That's a clearer copy.
Yeah.
At top of the page, I am not the month, day, and year buried at the mentioning place, and I am a little able to make any management for such institution.
56A?
Yes, 56A of the plaint.
Yes, mentioning at the place, and I am little able. Yes.
To make management for such institution, and I'm in hope that the government or the Supreme Court will devise the best institution for the public good. So he left it for the court or the government. Now, pursuant to that, please see what the court does, page 74. But please remember, it's for public good, it's not for Christian, not for the benefit of Christians. I've showed that that argument has not been dealt with by anyone. Now, please comes to page 74, which is the last page of the decree.
Yes.
But about 7 lines from the bottom.
And this court doth further decree.
And this court doth further decree and declare that the court shall at all time have full power of authority, either on motion by the Advocate General for the time being or otherwise from time to time, to make such alterations for the establishment and management of the school as they may. So, specific power given under the decree by which the school was set up to alter the scheme.
Yes.
Old equities.
This court.
Decrease in old equity.
Now, my lord, I am sure my learned friend, he now can't act as a jack in the box, but he's doing the near equivalent of that. Now, my lord, thereafter, so my lord, specific right given to do so. Now, my lord, this is my second point. My third point is, admittedly, this power has been exercised to alter the decree repeatedly, not once, but a number of times. The first one, if your lordship remembers, is the one he relies on, 1944. The court altered to put in that restriction of Christian. So that's one alteration. Admittedly, power exists. Thereafter, there is one more modification by way of a clarification, which says that this restriction of the governors being Christian applies only to the ex officio ones. It does not apply to the additional directors, the four additional governors. I'll show that to your lordship in a moment. Just pull out the page number. It also goes on to say at that stage that whether the scheme requires amendment or not will also be finally decided in that suit. Please take page 91. I don't want to trouble your lordship for too long, but please comes to page 91. But these are there in my notes and I'd argued it. No one has contradicted it once. Please remember that I've argued it. Please take the second paragraph. Prima facie, the aforesaid construction appeals to me, notwithstanding the incongruity to some extent of the bar to acting or functioning as such imposed upon the non-Christian ex officio governors, although the bar was not imposed upon non-Christian additional governors. So the bar is not there on the non-Christians. So, my lord, additional governors can be non-Christian. Then it should be noted that the additional governors were to be elected by the governors who are Christian, having knowledge of the said proviso. So, my lord, they've been doing all through with the knowledge of the proviso. Prima facie, therefore, it seems to me that the respondent numbers 4 to 7 were validly elected or nominated by the ex officio governors, namely defendant numbers 1 to 3, etc. And then, my lord, it goes on to say that this will be decided at the final hearing of the matter whether it needs to be changed to remove that restriction. Where is that portion? Yeah, I know it's there somewhere. Where is that portion? Yes. But please comes to page 94. Although, not the first major para on top, although most of the office of the holders whereof were appointed by the decree of 1832 to be ex officio governors have ceased to exist, the first three respondents are holders of 3 such offices. The scheme as framed by the decree of 1832 as amended by the decree of 11th March 1980. So, we had one more amendment in 1918 and orders dated 18th February and 20th September 1948 may be changed by this court at the final hearing of the suit. So, the court recognizes that it can be changed, or rather it will do so.
No, final hearing of the suit of which suit?
That suit, not that suit. That's a new suit, an independent suit. If not, I'll give you a lordship the cause title, which is at page 79.
Just a minute.
I'll tell you, lordship, what that suit was about. Not the suit is not suit number 2602 of 1967, which was ultimately dismissed for default. Now, so it's not in the old equity suit. My learned friend keeps saying that, look, if you want the modification, it has.
Thus, if the construction of the said Article 24 with General Martin on the Supreme Court is to be prevailed, then the said decree may merely recognize the provided for the right of establish and maintain education institution of Christian. The fact of majority of the students of the schools belong to the community.
Lord, the issue was this. First, Lord, the appointment of a principal by the Board of Governors is what was challenged in the suit.
Correct.
Now, principal. The question which arose was whether the governors had the right to do so or not. Now, in that context, the court decides, number one, the board of, not the additional governors were entitled to be non-Christian. Therefore, the meeting that they held where they appointed the principal was valid. This is what is decided there.
Correct.
So, the challenge failed. There was also a challenge to the ex officio governors, and to that the court says, look, that question about whether they should only be Christians or whether that needs amendment, we will decide finally at the hearing of the suit. But the power of the court to do so is not unchallenged over here. That the court can, the court's power to amend it.
Yes.
So, this is one more order which recognizes it.
Yes.
Now, this suit not ultimately came to be dismissed. Not that's recorded in Justice Devanshu Boshak's order. I don't need to trouble you. Not I have mentioned my note at page para 5.
Yes.
Now, so this is the next instance. Your Lordship will also please bear in mind the reason that the court has been looking at the issue about whether it should be not Christian only. Your Lordship has seen some of these officers cease to exist by then. Also, there was a second factor, Lord. This alteration was contrary to the scheme of the will and the original scheme framed. It was completely against the scheme. So that is why not the court has been looking at this issue. Then, my lord, in addition, please also, so my lord, as I have stated, not the will.
What is the 67 suit?
Yes, not 67 suit, not I'll just show your lordship from the order itself. I told your lordship, But it was a group of parents who were challenging the appointment of a particular principal by the Board of Governors. And in that context, they were challenging the composition of or the power of the board to do so. That was the scope of the suit. But that's also mentioned in my note. But it was there in the earlier note. There's hardly a few things new. Not generally taking care of his submissions. I've added a few paras or a few lines here. So now additional factor. I've given your lordship 3 factors. Will required it, the court to frame a scheme. Court specifically, when it frames it, says that the court retains full power and authority to amend it. Pursuant to that, as many as 3 amendments are carried out before 69 that I've showed your lordship.
Yes.
Including one that they rely on. They rely on the order of 1944. 44 itself was an alteration. Not if it's not permissible that 44 order goes, I'll be happiest. Not lastly, not out of the same will came the Lucknow Lamatnia, which does not have the same restriction. That is also under an order of this court. So, my lord, this has been the practice. The court, my lord, is really in the nature of a guardian or a parent to the school. Nothing can be done without the court say so. And the court has been doing so for the, my lord, last 180, 90 years without interruption. From 1830s to 200. For my learned friend to come and say that the court does not have the power to alter, not, and only the church or the Bishop of Calcutta will have the power to decide what he wants, not, is perhaps not completely incorrect, not, and is misconceived. Not. Now, not, please also bear in mind, neither the will nor the court decrees not imposes any restriction on a change to the scheme.
Yes.
So, if a change is required to make it not more contemporary, as is observed by not 2 division benches, I'll show that to your lordship, then not that power must be exercised. Now, on this aspect, my learned friend had made a submission that there is a division bench judgment of 2000 which says that no change can be made, any change will be beyond jurisdiction. He's kept saying that again and again. Now, my lord, I'll have to show your lordship this because I told your lordship orally, and it's there in my earlier note, not what was the scope of the suit. Scope of the, my lord, proceeding was this. School wanted to grant a lease to ICICI Bank. That came up for approval because it is under court supervision. So, school came for approval of that grant of lease to ICICI Bank. And there was nothing else over there. There was no challenge to the Board of Governors. There was no one asking for a new scheme to be framed. Now, for some reason, the learned judge got annoyed. I'll show your lordship, it was beyond the scope of the suit and applicant. He got annoyed and he said, the appointments are all wrong, and he set it all aside. Against that, my lord, there was an appeal filed.
Appeal set aside.
Appeal was uncontested. It set it aside.
Correct.
And the reason it says it is without jurisdiction is because it was not even in the prayer. So the point of jurisdiction which is decided is not the court's power to amend or not to amend in an appropriately framed proceeding. That's not what is decided. Let me just...
Where is that 2007
yes.
order?
Now, my lord, please comes to first, volume 2 of the plaint. But I'm just showing straight from, just to cut time, I'm showing from the division bench. It sets everything out.
Page?
Page 148. I can show your lordship, otherwise the trial court also, but not necessary.
148?
Yes, 148.
Yes.
Bottom of the page.
Yes.
So, my lord, before that is the recital, there's a lease, there's a grant of NOC by the income tax authorities, then, lord. Right at the bottom of the page, in these circumstances, petitioner made an application by way of a petition dated so-and-so before this court for the following reliefs. Then, my lord, your lordship will please turn, skip one page because this is not the typed version. Typed version, if your lordship turns the page. So, the prayers are, this court would be pleased to permit the petitioners to grant a lease. That's prayer A. Prayer B, court would be pleased to permit petitioners to obtain sublease. Prayer C, such further orders. So, completely beyond the scope of the petition. Court in that, my lord, superseded the board, etc., said everything is bad. Now, my lord, if your lordship comes to 154A,
Yes.
right at the bottom of the page, the question for consideration in the application, wherein the order was made. Not this is that order setting aside.
Yes.
It has been submitted whether or not permission should be granted to the petitioners to grant of a lease of a portion of so-and-so premises and conditions mentioned in the draft lease annexed to the petition dated so-and-so. Further, whether petitioner should be permitted to obtain draft lease of the first and second floor from ICICI. Further matter for consideration whether proposed lease or sublease for which permission was sought would meet the need of the school and be beneficial or not. Other questions or matters which were submitted were not germane. So nothing else was germane to it.
Yes.
It is in this context that the order is set aside.
In this
That your
said
lordship
order,
find the next page. Accordingly, we are of the view that the order passed by the learned single judge directing supersession of the board and appointment of new governors and governing body is beyond the competence of the learned judge and is without jurisdiction, and the said portion of the order is set aside. So, my lord, the lease itself was permitted. Supersession of the board is set aside because it was beyond the scope and subject matter of the petition and hence beyond jurisdiction. Yes.
155 second paragraph.
155. The order dated 12 July in our view has the effect and would defeat the intent, object and purpose of Major General Claude Martin, founder of the school, expressed by his will as interpreted by the courts, including Judicial Committee of Privy Council and its predecessor. Alteration directed by the order would not be in conformity with the object, intent and purpose and would have adverse effect on the ideals and basis on which the school is founded. Further, this is the line which my learned friend relies on. Now, further, the Christian character will be changed as was not the intention of the testator. One sec. So, what is the position here? Single bench could not have ruled on whether it's a good school, a good board or bad board. So, if they could not have, the appeal court also could not have. And I've showed your lordship, this is a stray observation in what context? The will does not say Christian. Will does not say Christian.
Correct.
1832 scheme does not say it's Christian in character. This is a stray observation, not in the context of the fact that the board has been removed by the judge, saying that, look, can't be Christians in today's day and age. So, court says, look, this is against the tenor of the will. But please remember, if the order of the learned judge on this aspect was without jurisdiction, then an observation on this is also not completely arbiter and without jurisdiction. There is no finding on this. Rather, there is no argument on it. No one, it was not an issue in that application or appeal. We had also given a judgment when I had argued it, which is also mentioned in page 6 of my notes, of these notes. But once a court holds that it has no jurisdiction, any observation in it is also without jurisdiction. There is judgment which we had not cited earlier. But page 6.
Yes.
Top.
Yes.
So, this also I dealt with. So, now, there are also two division bench judgments after that which say that the alteration is required. I'll come to that. So, please remember that Justice Barin Ghosh's order was not the subject, the supersession of board was not the subject matter of the proceeding. It was done suo moto. That your lordship has found page 126. Hence, it was without jurisdiction. Minority character was not an issue in that proceeding at all. Please also bear in mind that the school did not claim to be a minority institution then. According to them, the certificate came in 2010. So, 1996 or 2000, this issue could not have been involved at all. So, therefore, this stray observation regarding Christian character of the school is of no effect over here. Then, Now, my lord, the will and the judgments therefore don't come in the way of my lord, alteration of the scheme. Now, two other places, my lord, which I point out, two division benches have said that, my lord, this is required to be done. My lord, first, your lordship will take, my lord, Justice Shonji Banerjee's order, which I have annexed to the note, my lord, for convenience. Annexed to the it's annexed to this notes, my lord, for convenience. My lord, please just come to, my lord, the annexure, which is at page, my lord, not the first annexure, my lord. There's only one annexure. My lord, please turn to page 2 of the order. The matters of some importance and the slippery technical arguments made on behalf of the respondents would have the court miss the wood for the trees. The appeal arises out of an interlocutory order passed in a suit pertaining to certain grievances in the management and administration of La Martiniere School, Calcutta. One of the reliefs claimed in this suit is a scheme of management or administration to be put in place. There's a bit of history which can't be overlooked before addressing the present list. But I'll use this as my argument because this learned judge could write a lot better than I did. Not his words can be not sarcastic and strong. There is an old equity suit pending for nearly 200 years, pertaining to the will of Claude Martin and the school set up as a consequence thereof. There is no dispute that a decree was passed in the year 1944 by this court, framing a constitution for the school. 12 ex officio governors were to constitute the board of governors of the school. Posts are indicated as follows, and your lordship has seen they are all not eminent people. Then, my lord, after this. However, the immediate succeeding clause in the decree dealing with the constitution of the board of governors of the school provided that no person officiating in the aforesaid offices who did not profess the Christian religion would be eligible to exercise or perform any of the duties as ex officio governor. It must also be noticed that 12 ex officio governors were empowered by the decree of 44 to co-opt 4 additional governors every year from the 16-member board of governors to run and administer the school. It appears that the constitution of the school as framed in 1944 decree has not been amended, nor does it appear that any meaningful attempt for the purpose of amending the same has been made. The decree and the constitution, just relax here, and the constitution indicated therein are quite anachronistic. Now, my lord, please bear this in mind. This is important. So it's now, my lord, become old-fashioned, my lord, 200 years old. The country has gained independence. The state is now West Bengal, and even Calcutta old is spelled differently. It appears that upon the first two named in the board of ex officio governors for long, not being persons professing the Christian religion, the third named in the list has taken it upon himself to assume the post of chairman of the board of governors and wield powers that the constitution may not have provided for the occupant of the relevant post. Further, since several of the other positions are no longer manned by persons professing the Christian profession, board of governors has effectively shrunk to 2 or 3, with the successor in office to the Lord Bishop of Calcutta and the nominee of St. Andrew's Church of Scotland in Calcutta being the principal persons in control of the board. Prima facie, it does not appear that the 1944 decree intended only 2 persons to control the board of governors. Now, Lord, please mark this.
Since 1944 decree.
That the 1944, it does not appear that the 1944 decree intended only 2 persons to control.
Correct.
If necessary, to respect the will of the founder Claude Martin, the permanent board of governors should not have non-Christian members. The decree could have been modified as the old equity suit remains pending and the perpetual overall mandate of this court continues. My learned friend says yes, but please see in which suit this is passed. The court wants to do it in that suit.
An interim order which
Now,
the appeal
as
court
far as
finally did not.
Lord, my learned friend has said, Lord, enough. Lord, I think now, Lord,
Why
as
do you
far,
say an
please
interim
see,
order?
yes, please see this. As far as the present suit is concerned, it was instituted by 4 persons who had been co-opted on the board of governors for a 1-year term and whose nomination was subsequently sought to be revoked. While it is true, as some of the respondents suggest, that personal reliefs for the individual plaintiffs figure most prominently of suit, there is a prayer for a scheme of administration or management to be framed, and it cannot be missed that the board of governors as functioning in the recent past may not be in consonance with the decree of 1944. So, second thing recognized by the court. Respondent suggests that the scope of the appeal is limited and the interim order was merely vacated by so-and-so order upon the court noticing the 1-year tenure of the 4 plaintiffs would have run out. However, it cannot be missed that the board of governors of La Martiniere Is not the board in accordance with the decree of 44? My learned friends are relying only on that decree. There's an observation that that board is not in accordance with the decree. SLP against this order, non-interference, I'll show that to your lordship. The appellants complain that the major policy decisions have been taken.
SLP or
Yes, every order. There is no order against which they have not gone, which is why this delay. There are multiple SLPs against the same order. They failed the first time, they file a second SLP after 1 year. I'll show that to your lordship. The appellants complain that major policy decisions have been taken by the Board of Governors, headed by the present Bishop of Calcutta, for establishing branches or new schools in the name of Lamartine in conjunction with other schools. But it was called Lamartine Oxford Mission. It would be in the best interest of all concerned, and that all decisions taken by the board after institution of the suit or after passing of the initial order be not immediately given effect to, except those pertaining to day-to-day administration and functioning of the Lamartine Calcutta boys and girls. No decision pertaining to any new school should be given effect to, or any steps taken in pursuance thereof, till the matter is decided. It may be necessary, now my lord, please see this, it may be necessary to make the constitutional documents more contemporary and revisit the manner of composition of the Board of Governors of the school in this suit, not in the old equity suit. Since such part of the exercise may be purely for the interest of the school and, my lord, mark this, not adverse to any person, the exercise may be taken up in the present appeal to preserve and protect the interest of the school, which ought to be the paramount concern of the court. The appeal and applications will appear a week after reconvening. It will be open to all the respondents to file affidavits, particularly to indicate how the new constitution of the Board of Governors should be made. Since the EO nominee plaintiffs would in any event have limited office after the period of 1 year, such plaintiffs can't be restored to position apparently occupied at the time of institution of suit. For the moment, the current Board of Governors will continue to function, will not take any major decision or precipitous action. Now, my lord, what follows thereafter is, my lord, vacations come, 3 adjournments taken, learned judge is transferred from Calcutta, he goes off to Chennai, adjournment after adjournment, then, my lord, finally the matter is heard before. Now, my lord, please see the Supreme Court order. Page 76 of GA6. Sorry, G8. Oh, I'm sorry. I'm sorry.
Welcome.
But I'm sorry, but past 3:30 I had.
Been troubling your lordship for quite some time.
That the order of the Justice Basak.
No.
No.
Against this,
Against
there was
Justice
order.
Banerjee.
And
But your lordship has seen there is nothing harmful in that order.
76,
Yes.
nothing was done.
Yes. Now against that they go up in SLP against that order.
That order is page 76, 77, 70,
Yes.
71.
Yes. 76.
70, 71.
70, 71. Sorry, I'm sorry. 70, 71.
Passionate respondent, this does not take
The
away
appeal
the
is
matter
pending
of
before the divisional bench. It appears that a preliminary hearing, the contour of the disputes have been set out only to facilitate the respondents to respond to the same. So they were asked to respond. This does not take away in any manner right of the petitioner to contend that such issues need not be decided in the appeal. As abundant caution, we state that any observation made naturally will not color the final hearing of the appeal.
Well,
Now,
this is important. Well, these 3 lines are really important.
Please come to. Yes. I am.
Well, it's the last 3.
The last 2 lines. Every time in the SLP, they having the good 2 lines.
Yes. But not your lordship will have the last line and the last say. Your lordship will have the last say. Now, my lord, final hearing of that appeal. Lord, subject to final hearing. Final hearing, your lordship has seen Justice Posak's order. Come to page 100. Come to page 100.
No observation.
No last 2 lines here. No last 2 lines here. Lord, this is middle, right in the middle. Para 44 at page 100.
Yes.
This court had retained the jurisdiction to pass orders in the old equity suit while passing the initial decree and the amendment thereof. This is what they keep saying, yes to your lordship. Here's the hissing, Lord, jurisdiction of this court had been invoked earlier in the old equity suit relating to management affairs of the 2 schools. Independent of the pendency of the old equity suit, approach has been made to this honorable court relating to the management and administration of the 2 schools in 1967 by way of a suit, which was, Lord, I told your lordship that suit was struck off the register. So that's 67 suit. So, my lord, yes. So it goes on to say that it can be done in this suit. But they say we do not do so because there is no prayer in that application. So please go to trial court and do so. That I'll show your lordship on the next day. Not at page. And then, not two things. Two things, blood, I need to show here. If your lordship just permits, I'll not place this just now. But blood, we can't finish it. I have to deal with Aligarh Muslim University. But blood, I have to deal with Aligarh Muslim University. Your lordship will have to give me blood another half an hour, blood, or 15 minutes. 15 minutes one day.
And 5 minutes to me. 5 minutes to be.
Then again, last sentence can't be. Now, my lord, this time, no, last two sentences can't be his.
Only 5 minutes only to clarify that factually he has made 3 incorrect
Yes,
suppositions.
yes.
First I will hear. Yes. That's what I was saying, that he's a secretary. He is a
Well,
secretary.
your lordship should have heard Alma first.
Miller's, your lordships will have to grant us 5 minutes after everybody has concluded, just to clarify. My senior may be granted 5 minutes.
5 and 5.
No, only 5. We'll share it.
Only 5 minutes would suffice.
We'll
Only
share
5.
it. We'll share it.
Counsel for the defendant number 8 has argued the matter at hand and has filed a fresh writ of written submission after serving the copy to the other party. Let the same be kept in the record. Due to paucity of time, hearing could not be completed on behalf of the defendant number 8.
I leave it to your lordship.
I want to, in this case.
But I know, but I appreciate fully. I'm saying nothing, but I am saying nothing, but
January का कोई है? आज एक था दे दिया.
Any day your lordship gives me, I will finish
No,
off.
but I wanted 2 dates so that all the matter can all.
But one date will be very well.
Both,
I
all. Of January, then I will again. I will.
Can it be item number 1 on any day? Not instead of fixing a time, we'll come. Your lordship need not fix a time. Item 1 on any day.
Adjourn motion में specially fix है ना? आठ और 9 में क्या है? उसमें टेस्टामेंट ही फिर नहीं रखना।
बार-बार क्यों बोल रहे हैं?
12 नून करके फिर टेस्टामेंट ही हटाना हो। 30 मिनट तो कुछ होगा नहीं। 9 नॉन कमर्शियल है ना? 8 and 9 रहेगा 11:30। 8 जनवरी 9th जनवरी 11:30।
Deeply.
Grateful, your lordships. Obliged.
3:45 matter today, so it's not possible. My lord, the matter is again fixed on Monday. So Monday.
Come on Monday. Any